On the prayer made by Mr. S. Banik. List the matter on Monday. What about Tuesday? Tuesday better. Monday better. Interim to continue till Tuesday. Yes. Item 14. Oh, 15. Reserve station. When do you want? Then, if the issue is covered, then what remains? When does he want it? After 5th, there is it. Give it. 13. On the prayer made on behalf of Mr. S.K. Kejriwal, Learned Counsel for the petition. This is the matter. Huh? Item 15. Actually, you're for the respondent. On the prayer made on behalf of Mr. S. Only Mr. Kejriwal's name is here. Wakalat number is there. Okay. On the prayer made on behalf of Mr. Dr. A. Ashok Sharaf. This is the matter on. Give a date. 13. Interim order to continue till 13. It's being filed. Usually they mention it after it is filed. By whom? Yes. Huh? 16, yes. Who appears? B. Datta. Okay. Is there any stay order? There's no stay order. Okay, right. On the prayer made on behalf of Senior Counsel Mr. B. Datta, who is having some personal difficulty, and that the same is not objected by Mrs. A. Bhattacharya, counsel for the AFC. For the point number 3. List the matter 5th September. Is there any, there's no stay order, no? 5th September. 18. All the hearing will go, yes.
Adjournment to the lordship. Mr. Pathak has some personal difficulty. I am for the respondent, lordship.
Huh?
I am for the respondent.
You're praying for adjournment.
Yes, lordship.
Any objection? On the prayer for adjournment, any stay order
Yes, lordship. There is in the
in your favor? You're the petitioner. Why do you want adjournment?
lordship, he has some personal difficulty.
Whose personal difficulty?
Mr. B. Pathak, lordship.
B. Pathak.
Lordship.
On the prayer for adjournment made on behalf of Mr. B. Pathak, which is not objected to by Mr. B. Sharma, appearing on behalf of Dr. Ashok Sharaf. List the matter. When? After? This is the matter after, this is the matter after a week.
Obliged, Lordship.
New matter.
I think, Your Lordship, in item number 9 and 10, Your Lordship, on the last occasion, we were given the liberty to, can you mention the matter for an
Yes, yes. You want to mention
update for
upgrade. It will come in time. There won't be a problem. It's only item 9 and 10. Don't worry. They will do it with.
Yeah, please, your lordship, I am praying for listing on WTC number 5530/2022, lordship. On Monday for orders, lordship.
Why?
Lordship, this is a.
When was it last listed?
This is a matter of lordship regarding tender, lordship, for refreshment room of IRCTC.
Huh?
lordship. For refreshment room of IRCTC, lordship.
22 matter. WPC in 22. Is the matter has become infructuous or what?
No, lordship.
No. Give a date, not give a test this Tuesday, I think.
Obliged.
the last, on April 2024, and the order was updating ways. So now it has been one.
Matter relates to
It's related to land.
land matter.
Property,
Land matter meaning what?
land trust,
Land?
land trust. We are the owner of that particular land and
Bench 5, I think. Land grabbing is not here.
not
Which one?
for, exactly land trust. There is a like protection scheme not like
Madam, please know the facts of the case. Next. Next. You read in the meantime. Don't come don't come blindly to the court.
Fair for listing matters regarding non-payment of contractual bill. That similar matter has already been covered.
Give a date.
For matter, the matter is pertaining to GST refund. That data that will be listed on next week, Monday or Tuesday. It last came up in the month of March, where it was said that after 2 weeks it should be listed. Both are regarding tender. It was lost instead of 16 February and one.
Give a date. Next week.
30. The matter for the
Huh?
matter.
New matter.
No, the other party was given the chance to give an affidavit for 2 weeks, but it will not be listed for last 1 year.
Okay, give a date. Yes, madam, what is the matter about?
already built a school in that particular land without taking any MOC from.
The respondent has built a school without taking any. And who is the respondent? The government.
GMDA and the respondents, NDA,
When do you want it?
7 possible.
Okay.
I think one.
Huh?
If your lordship should recollect, in the month of April, we had approached this honorable court for a lockdown that was passed on a tea garden in regards to a management and employees problem. That your lordship has passed it over page 92 and given us a protection by saying that the state authorities will help you. There is certain kind of protection that will be granted, we can run. April, May, June, we have been running. Dues have been completed. Now in the month of July, your lordship, because one of the allegations made by the management is that the person who was distributing the salaries against whom there is a complaint for misappropriation of funds, an inquiry has been conducted. Since the date of the inquiry has been conducted, the garden has again gone back to the same situation. There's a huge problem. They are not letting us work. There is a payment of around 18 lakhs due for the month of July.
You're for whom? You're for the management.
For the management. Now, we have requested the authorities that please provide some more security, otherwise we will not be able to manage the affairs of the government. In that context, your lordships, we've got in certain additional document We are requesting your lordship that at least some kind of a further protection be granted, otherwise we will not be able to run this garden like this.
Yes.
There's a huge pressure for payment of dues also. Your lordship.
No, Lordship, on each and every issue, this honorable court will not interfere. Direction was for giving the appropriate protection, Lordship, that has already been given, they cannot deny it. Because of some.
So is the protection still there?
Yes, it's already there, that they are still,
So?
they are enjoying their protection, and they are not complaining that we are not given adequate protection.
There's still 20 copies. I put it in the mail article. That email is annexed to your lordships at page 105 and 106. The manager was around, his bungalow was attacked. Now, if this is the situation, your lordship will not be able to perform, and this has been going on to 5th of July. After the entire investigation has been started against that individual. And if I can't work, I can't pay. That's my problem.
So you take out that person from that post.
There's already investigation going on, inquiry of the investigation is on against him.
No, so you take him out from that post then. It's not that the person who is a cashier or something has to remain a cashier.
Yes, Lordship, if some person is,
There was an opportunity granted to him, he didn't even come and participate in the first occasion.
Mr. Counsel, that's not the issue. Why don't,
Suspended up.
then,
The month of May, but this has all been happening at his behest. That's the problem.
we cannot,
I understand the problem. but I
do you want this court to come with a big danda and stand outside your gate or something?
Protection cannot be educated. That's all I'm saying. It's been granted already. 4 policemen cannot control this. That's all I'm saying. Your Lordship.
Where, where is
Yes,
the,
Your Lordship.
where is your representation to the authorities?
Yes, Your
with
Lordship.
regard-
Your Lordship, be kind enough to come to page 105.
105.
Yes,
Yes.
this is an email which has been written to the police as well as to the authorities. As received from the manager of so and so, the situation of the garden is not appropriate and the manager is not in a position to.
Where are you reading? Where are you reading? 105. Okay, yes.
That's
Yes.
the email which has been mentioned.
Ah.
And the addresses are mentioned on the. top.
From Rajesh Jalan. Who is
Yes.
Rajesh Jalan?
Yes. And
That's you.
to-
Rajesh Jalan is you.
Yes,
Okay.
and it is to the authorities, which is police,
Ah.
the provident fund. And then as received from the manager of so and so, the situation of the garden is not appropriate and the manager is not in a position to lodge the FIR. We will be lodged a proper FIR once we feel secure. In the meantime, to come to know that a mob led by so and so forcefully shut the tea factory and bring out all the workers from the factory. It is to mention that yesterday about 1,000 kgs of green tree plaque has yet been processed, security provided by the administration. Also helpless to do anything. Further down, your lordships, at the end, we've written another mail to the deputy commissioner. And in which over the page on 106, we will mention the 2 incidents that has happened. This is to inform you the 5th of July, an incident for harassing the manager for the whole day till the evening by a section of workers which led to so and so a dismissal worker, where the entire police and the administration was present in front of the situation. However, on 26 at 30 AM, the manager of so and so was monitoring the field in block so and so, but was carried out by a section of women workers led by so and so, and many other instigated by Shri so and so as dismissed worker, and Deepak so and so, who is also a suspended employee. The manager gypsy was stopped, carried out and thumped the body of the vehicle. He tried to snatch the key of the vehicle and also threatened the manager with dire consequences. The next paragraph is extremely important. The main demand was whether the labor payment being made on 27th Saturday, or as a notice to the administration mentioned, the wages payment will be made on 31st, because I couldn't do the payment because of non-working. And the daily has been plagued by the placards which would not meet the expenses. I am not able to do it. I have now postponed and requested them to give me time till 1st, or till 3rd.
To pay payments, to make payments.
We have to make around 18 lakhs of payment to the workers. And the next page is the notice which I have issued on 28th of July. That's why I'm before your lordship. This is for your information that all the concern that in response to the notice that so and so the administration is further informed that due to non-function of the factory and factory workers prevented from misspells on 27 and 28 to come to for 1,000 kgs of green which lying on so and so is damaged. I can't do it.
Anyway, the issue in this writ petition was with regard to the cancellation of the lockout order issued by you, correct?
That has been,
Now that issue is gone.
yes,
That is now, what remains now? Only your security.
that is already which has been provided, but with all due respect, I don't think that is sufficient enough for us to handle the situation like this. If it's somehow-
Then now what else can be done by this court? Only direct that, that matter should be looked into, that's all. What else
Mr.
remains?
Lordship, at least some kind
What,
of
what else
formalities are
remains? No, no, that's one. Now, besides that, what else remains in this writ petition?
This, we will have to, obviously, the investigation will continue. There is already an inquiry officer which has been appointed. That we will do it. But in regards to this, at least if some kind of a permanent solution is not found out, we will not be able to run it like this. And this problem is going to keep coming up. We
Now-
have a similar position in April, now again in July, we are facing the same problem. And the next page, your watches at page 108.
Yes,
They have not even taken any action against it. We will be informing the authorities about these problems. So that's my only grievance before the lordship. Rest I leave it to you.
Lordship, this is only a petition to delay the payment of salaries to the waiters.
no, they said that they will pay it on third.
That is, Lordship, now since when it is postponed, Lordship? Initially it was 26/7, now 26/7, 28/7, then 31 fixed.
No, no, you make
And
a
now
payment
they are
by
again
third.
going to
Are you
3rd
making
of,
it by third?
3rd of August.
Third of August.
Yes, if I am able to function. Because
You have to
in terms of this
function.
notice- In terms of this notice, my factory is closed, your lordship.
No, no, you have to
They are
function.
stating that factory is closed since 27th only,
That's
only
the
on
thing.
27th of this month, Lordship. And they are not paying the salary for the entire month.
No, no, you pay
So
by third.
definitely some unrest will be there,
We
Lordship.
will pay, we have no problems provided.
Huh?
We are able to run the factory. That's the biggest problem, challenge we face, your lordship.
Look, those, we cannot keep on, that has to be, the issue of security. That even the state cannot give you 1,000 policemen or something. It's not that.
I understand.
You'd have to, you see, the problem arises between you and the worker. You'll have to manage that somehow.
It was running from April, May, June, we had no problems. It's only after that investigation that started against him. This has again gone back to the same position. Before that, we were working. There was no-
Investigation against the,
Against the expelled, the employee who has been suspended.
that was, he was suspended when?
May, 24th of May.
After the order passed by this court.
The order was passed in April. He was suspended in the month of May. Inquiry is on against him. Charge sheet is filed. The inquiry is also is proceeding.
Anyway, we listed on 8th, on 4th.
Lordship.
Just to ensure that we have paid the workers by 3rd of August.
Lordship.
I requested on 5th.
Why? Office is there. Yes, 4th is a Sunday. Correct. Okay, we listed on 5th. You pay them and we'll see.
Yes, they will ensure that the salary is paid.
But then you also ensure, you also look into the letter, the email at page 105.
Lordship, to my information, even today also the concerned DC and SP is sitting, Lordship, with the management.
Okay.
Today also.
Okay.
I will have that instruction by the evening, Lordship. I will place it on 5th, Lordship. On 5th, I will place that instruction.
Okay, right. Heard Mr. R.B. Fugan, learned counsel for the petitioner, and Mr. P. Nayak, learned counsel for the state respondents.
So, Lordship, I am appearing
The-
on behalf of Advocate General, Lordship. On last date, he appeared.
Correct. But
Yes,
Advocate General is appearing for some party,
All, Lordship.
appearing for all the respondents. Right. This court by order dated 26/4/2024 had directed that the tea garden should start functioning and should be kept open, subject to adequate security being provided by the district authorities. First up. Mr. R.B. Fukan submits that in compliance with the order dated 26/4/24, security had been provided by the authorities and the garden was running smoothly since then. However, on termination, on suspension of the services of, Huh?
That is at page 101. He was shown first and then subsequently suspended.
of Manshuk Sankarika, 101, page 101.
He is an executive officer.
Who is the executive officer in the tea garden?
He was appointed as on 8th of April 2024 as an executive officer.
Who was appointed as executive officer?
He was promoted as an executive officer on 8th of April by the management.
And he was suspended on,
Subsequently suspended because of allegations of.
okay, anyway, that's an executive officer, comma. Trouble has again started in the tea garden, due to which the factory could not function and wages could not be paid on time. He submits that the 4 security guards provided by the police were not enough to contain the protest led a protest instigated by that Manshuk. He also submits that the management is planning to disburse the wages of the workers on 3rd August 2024. He submits that the representations and letters sent by the management to the district authorities have not been considered by the authorities. Mr. P. Nayak, learned counsel for the respondents, on the other hand, submits that as per his information, the district authorities, including the district commissioner and the SP concerned, are presently with the management. Is it? Are going to, are looking into the issue raised by the management, and they will take a decision on the same shortly. Next, in view of the fact that the management has decided to disburse the wages of the workers on 3rd August 2024, list this matter on 5th August.
Using regards to April, May, and June is already been paid.
In as much as no, before that, it will be paid on 3rd August. In as much as the dues of the workers for the month of
Till June has been paid.
Uh,
July is pending paid.
till June 2024 has been paid. So besides that, we'll close the matter after that. There's nothing else in this repetition.
The outcome of the inquiry happened, the thing that happens, Your Lordship.
Whatever, that is a different issue. That is a law and order issue. Your writ petition is basically with regard to the cancellation of the lockout notice. Now that lockout notice has gone for a 6 because of this order pass. Item 2. I should have recorded whatever he said. Where is the notes I made that day? I was looking for it yesterday. I couldn't find it.
That is, let me refresh your lordship.
You'll have to, because yesterday I was thinking I should have recorded what you said.
In fact, that was the whole idea of fixing it on a Tuesday, so we
Ah.
have some time.
No, and then I was looking for my notes. I couldn't find. It was supposed to be here. Anyway, tell me.
Facts are like this. There was originally an NIT on 8/5/2023 for supply of liquid,
Huh.
for supply of liquid medical oxygen.
Yes.
Now, there were, like in all other NITs, there were some eligibility criteria, qualification criteria. The respondent number 3 could not meet those. His technical bid was rejected, and he has preferred a repetition, which is still pending, no interim order. This WPC number 3428 of 2020. That was for a period of 1 year. And I got the petitioner hearing got the contract in respect of that particular.
Okay.
Now, there was a subsequent NIT on 23rd of February 2022.
NIT 23rd February.
2022.
Huh.
There were some eligibility criteria. As soon as the NIT was floated, the respondent number 3, he submits an application that your lordship will find at page 60. Your lordship will kindly come to page 60.
Yes.
What were the requests made and how the government responded? Your lordship will find it.
Yeah,
Firstly,
yes,
there was a criteria, in fact, I must point out to your lordship, in the NIP is annexed at page, the concerned NIP is annexed at page 51. If your lordship will just for a moment have page 51 for a moment.
yes.
Page 51 itself reflects the minimum turnover is 2000 lakh.
2000 lakhs?
Yes, with 20 crores basically.
2000 lakhs, yes, 24, yes.
And if your lordship turns the page to page 53,
Yes,
at the very top, your lordship will find page 53 at the very
yes,
top.
yes,
Your lordship will find MII compliance. Yes, MII it stands for Make in India compliance. Now, his very first request, your lordship will kindly look at page 60.
yes,
As our plant is located in Bhutan and the storage is more than 70 metric tons at our plant site, but Bhutan government doesn't issue any kind of explosive or peso license. So we request you to kindly change it as the bidder must have minimum 70 MT LRO storage capacity with or without peso license. He is asking waiver of the license itself. And your lordship will kindly see the
waiver
response.
of what license? Waiver of the MII, you mean?
Explosive license. No, what I was indicating is firstly, he admits that it is in Bhutan.
So
it
it's
is- it
that
is
the
not in
MII doesn't come into picture, huh?
Make in India compliance is
Not
that
there.
with automatically waiver he is asking for. Additionally, he is saying the waiver of the license also. And your lordship will kindly see the response.
Waiver of license? What do you mean waiver of license?
This is the explosive license
Okay,
because this is medical oxygen being supplied through tankers. So there is a requirement of a
odd
license.
license.
Now your lordship will kindly see the response of the government on the right. Rejected. The standard rules and regulations laid down by the concerned regulatory authority is to be followed for all purposes as per the law of the land for related services and support systems. Hence, the already mentioned criteria persist in the window. Now, second request he makes is kindly amend point number 1 as authorized distributor of manufacture of the manufacturer can also participate in the tender as the manufacturing plant is in Bhutan from India and we have import license of LMO, being the only company in India having import license from so and so, government of India. Accepted. So the requirement was that you should be a manufacturer within Northeast. So they accept that you can now take it.
You have not said no, you said India, not Northeast. Where is
There
the
is an
Northeast?
eligibility condition, which
So
says
you-
that you have to be a manufacturer.
So you have not shown me that.
I'll place that. Page 59. Page 59, condition number 2. The bidder should have more than one liquid medical oxygen manufacturing unit in Northeast India. With minimum combined installed capacity of 50 metric tons per day. Now, he is asking for a waiver that even authorized dealer should be allowed. Manufacturer should be waived. They accept it. Now, kindly come to this next request. Kindly amend point number 2 as the manufacturer should have manufacturing capacity of 40 metric ton per day instead of 50. This also they accept. Kindly amend point number 3, having experience of supplying LMO to minimum 4 government private hospitals having capacity from 300 beds instead of 500 beds. So this they reject. The original requirement was 6 hospitals with 500 beds. This is now rejected. Kindly amend point number 5 as bidder must have 4 tankers or else lease or hire LMO transport tankers with valid peso license with a valid agreement. The original requirement was this is rejected. Your lordship will find that original requirement was 8 numbers of tankers. However, what they do is they issue the corridor, which your lordship will find at page 62.
Yes.
So on the left side, at page 62, in the left side column, you'll also find the original requirement.
Yeah.
And in the right side is the modification. The original requirement is this: the bidder must be a primary manufacturer of LMO through air so process. Now they modify it to the service provider bidder must be an authorized distributor. So now they allow an authorized distributor instead of a manufacturer. Then second, they modify it as per his request from 50 metric capacity of 50 metric tons. It gets modified to 40 metric. That they don't stop there. They issue another corridor. Now, in spite of these relaxations, it still does not fulfill. At page 64, your lordship will find the next corrigendum. Now, virtually they accept all his requests. He is literally dictating terms to the tendering. Page 64. And if your lordship kindly turns to page 65, many of the things that were originally rejected are now accepted. So lordship will have a look at the corrigendum. On the left hand side are the original conditions, on the right hand side are the modifications. The bidder should have more than one liquid so-and-so manufacturing unit in Northeast India with minimum combined installed capacity of 50 metric tons per day, capacity assessment, etc., etc. Now on the right, you'll also see the bidder or manufacturer must have liquid medical oxygen manufacturing plant of minimum installed capacity of 30 metric tons per day. So Northeast goes and 50 comes down to 30. Now next, point number 3. The bidder must have experience of supplying to minimum 6 government private hospitals of minimum 500 beds. Your lordship will kindly see the modification on the right. 6 goes down to 1 and 500 beds goes down to 300. Now next, the bidder must have valid drug license for source of LMO. The modification is in the right. The bidder shall provide valid drug license from the concerned regulatory authority, so and so, so and so, so and so. Now, serial number 4, point number 5. The bidder must have minimum 8 liquid oxygen tankers. This was originally rejected. Now it is brought down to 4. So these are the modifications made. Then 5, original requirement is that you have to be able to supply within 12 hours. If your lordship kindly sees at page 66,
6 hours.
12 hours converted to 24 hours. Then storage capacity originally was 70 metric tons. It gets modified to 60. Now, after this, he submits his tender. And in spite of that, he does not meet these qualifications, which we have mentioned. We submitted a representation at page 68. In spite of all the relaxations given, he does not meet these qualifications. Serially, we have given bid document page 1, minimum average turnover of bidder 3 years, 2,000 lakhs. Please refer to so-and-so balance sheets of financial year 22, 23, 21, 22. The average turnover of MOPL, that is the respondent number 3 here, is, we have given it in the form of a chart. Your lordship find 2021, 760, 21, 22, 1,111, 22, 23, 1,008. Average turnover comes to 960. So he falls short by less than half. Now next, with corrigendum storage system point 2, the bidder must have minimum 60 metric tons LMO storage capacity with valid PESO license. Messrs. Meghalaya Oxygen does not meet the tender requirement of having a minimum 60 MT LMO storage capacity with a valid PESO license, as their current storage capacity is only 19.93 metric tons. When we
Okay, so then
when we point out all these things, what they do is this, page 70. Instead of rejecting his tender, they cancel the entire tender process at page 70.
Yes,
Entire tender process is cancelled. Now they come up with a fresh NIT. That your lordship will find at page 71. This NIT is dated 12/6/2024.
yes,
At page 71, your lordship will have a look at minimum average turnover. Now it is an open secret that he has only 960 lakhs. So it is brought down to 800. Now, if your lordship will kindly turn to the eligibility criteria at page 80. I am not troubling your lordship with the other conditions. All other conditions have been relaxed as per the originals issued earlier. All of them stood relaxed. In this particular case, we are concerned with clause 3. At page 80.
yes,
The bidder must have experience of supplying to minimum one government private hospitals of minimum 300 or more bedded. Next sentence is very important. They should have experience in supply of LMO. The extent of supply, if your lordship compares this with the earlier NIT at page 59, your lordship will have page 59 and 80 together. Earlier at page 59, the physical extent to which it was required is mentioned. The bidder must have experience of supplying to 6 government private hospitals. 6 has been reduced to 1. All right. Minimum 500 beds. They have reduced it to 300. Perfect. Next sentence, your lordship will see at page 59. At page 59, earlier tender, the physical extent of the experience required was mentioned. They should have experience in supply of minimum 30% of the tendered quantity in any of the last 3 financial years. Now, if your lordship compares it with page 80, that has been very tactfully removed. They should have experience in supply of LMO. What extent? 1 kg, 2 kg, because the requirement, I will show from the NIT itself, the total requirement is of 6,955 metric tons total.
6,000.
6,995 metric tons of liquid oxygen. is the requirement.
6,995.
This, your lordship will, we have done the total calculation. Your lordship will find the total requirements are given at page 79. There are in all about 11 or 12 medical colleges and hospitals. The total requirements are given. We have added up this total quantity. It works out to 6,955 metric tons. Now, what they say is they should have experience in supply of LMO. Experience of how much? Does that mean that anyone who has any one hospital, 300 bedded hospital, I have supplied 1 liter, will it suffice? All right. This is covered by page 73. The reason is, your lordship is aware, after the Supreme Court judgment in Rona, para 9, the parameters have been laid down. That what are the vital criteria to be adopted and evaluated by the tendering authority. And 3 criteria, I will refer to that judgment later. One of the things that was conclusively laid down was that the tendering authority has to make an assessment of the capabilities, the extent of the capabilities. So the extent of the capabilities, how do they judge? This is how it is mentioned. Clause 4 at page 73.
Yes,
Past experience of similar services. The bidder must have successfully completed similar services over the last 3 years. That is the current financial year and the last 3 financial years, ending month of March, prior to the bid opening. Either 3 or 2 or 1. What is the extent? If it is 3 similar completed services costing not less than the amount equal to 40% of the estimated cost. The estimated cost your lordship will find at page 72. So if it is 3 similar works, it has to be 40% of the estimated value, which is at page 72. The estimated value is 13.91 crores.
No, page 72, 13 point, okay.
The estimated value is 13.91 crores. And when we calculate, your lordship may just make a note. against those-
Just a minute, 13.91 crores, yes. So 40% will be, 40%,
5.56, I have, your lordship may just.
okay, you have calculated 5.56
Five,
crores.
if it is 3 works, so those 3 works will have to be of the value of 5.56 crores
Hmm,
each. Or if it is 2 similar works, it is 50% of the tender value. 2, so either 3 or 2 similar completed services costing not less than amount equal to 50% of the estimated cost,
So it will be 6 point,
96,
uh,
6.96 crores. Or if it is 1 work, 1 completed
80%.
service costing not less than 80%, that comes to 11.12 crores. So the tender itself gives an option that if you have done 3 small works, it has to be.
so the eligibility criteria provided in page 80 has to be read in terms of page 73. That's
Because otherwise, the extent of this similar experience cannot even be judged. Now, he submits his tender. And they, if your lordship will kindly just for a moment have the government affidavit, your lordship will find very interesting.
No, before that, then now this is there. So he has been awarded the tender.
He has, first they determine him to be technically qualified in spite of not having these experiences, past similar experiences.
And
They do not even discuss it in the tender committee minutes, and they award the work because his rate is lower.
okay, so he's L1.
He is L1.
You are L2.
I am.
How many tenderers were there?
Just
Two.
because liquid medical oxygen is a very,
Okay. I thought maybe after COVID there'll be a lot of these plants.
because the whole process, that is why he has had to run to Bhutan.
Okay, so basically, so that is the case. So then now you are saying,
Your lordship will kindly have the tender committee findings, because this is the next stage. Once he submits,
page,
your lordship will find it at page 219. That is the last page of the government affidavit.
tender committee minutes.
Technical committee. So this is the technical evaluation.
Technical committee minutes dated
This is dated 9th of July,
9 July 23,
24.
24.
24, because the press NIT is dated 12/6/24.
Actually, this case is very new, that means.
Yes.
Okay. So page 219.
209.
Okay, yes.
Your lordship will kindly have a look. Not even a discussion, just one chart is prepared. Whether technically.
Okay, so
qualified-
you are both qualified. Okay.
Yes, that's it. And they hurriedly open the financial bits. And naturally, he knows that he does not have the technical eligibility. He will naturally resort to predatory pricing. And as expected, he has quoted such a bid, which is virtually impossible, just to get the tender. Bids are admittedly lower. I am not even getting into that. Now the question is whether he could have been shown as a technically qualified bidder. When
Appearance cannot be shown as per page 72. No, does not appear to be qualified.
they come up with a very interesting stand, your lordship will kindly come to the government.
Okay.
They are now trying to say that that clause 4 is not even applicable.
Clause 4 of page 72. The government affidavit.
Government.
Okay.
Very interesting. I will place those clauses. If that be the understanding, God save this country.
You mean God save the state? It is not a tender of the government, the state,
Government.
the government of India.
I stand corrected.
Okay, clause 4 of page 72 is not applicable.
That is the, and they say it in a very roundabout.
Okay.
That is why I must place that affidavit itself. The lordship will kindly come to page 189. This
Yes.
is subparagraph Roman 1. of paragraph
The affidavit of respond number 2.
Response.
Page,
Page 189. This is subparagraph 1 of paragraph 3.
this is paragraph 1.
No,
Paragraph, okay, yes. Para 3.31.
3.
Yes.
May I read it?
Yeah.
That the bid documents section on past experience of similar services referred in page 3 of the bid document under clause 4, past experience of similar services, is a default GM generated template
Okay.
for past experience of similar services in service category bid, whereas on bid document scope of work, reference in page number 3 of the bid document under so and so, the past experience criteria outlined in point number 3 of the terms and conditions under technical specifications for supply of liquid oxygen, which states that the bidder must have experience of supplying to one government or private hospitals of minimum 300 or more bedded. They should have experience in supply of LMO. Supporting copies of supply order, contract approved price with satisfactory completion, so and so in support of this must be provided. And the aforesaid clause 3 supersedes the above mentioned clause 4 as per disclaimer at page 8 of the bid document. This bid is governed by the general terms and conditions stipulated in bid and service level agreement specified to this service as provided in the marketplace. However, in case of any condition specified in general terms and conditions is contradicted by the conditions stipulated in service level agreement, then it will override the conditions in the general terms and conditions. So what they are trying to say is, for your lordship's convenience, may I take your lordship to the relevant clauses that they are referring to?
Yes.
Your lordship will kindly turn to page 78.
Yes. Yes.
Towards the bottom, your
Yes.
lordship will find a paragraph just above that Hindi portion.
The bid is governed.
The bid is governed by general terms and conditions. Your lordship will find that this portion is underlined. That is because this is a hyperlink.
Hyperlink meaning?
The moment we click on this, another page opens up in the website.
Okay.
And what page opens up, I will take your lordship to that also. Now, what it says is this. The bid is governed by general terms and conditions.
Yes.
The bid is governed by the general terms and conditions.
This bid is governed.
This bid is governed by general terms and conditions stipulated in bid and service level agreement. Your lordship will kindly note this one. And this also is a hyperlink specific to this service as provided in the marketplace. However, in case of any condition specified in general terms and conditions, it's contradicted by the conditions stipulated in the service level agreement, then it will override the conditions in the general terms and conditions. Now, what opens up when we click on general terms and conditions is that page 130.
Page 30.
100.
Yes,
At the very top, your lordship will find that heading, general terms and conditions.
yes,
So when we click on that page 78, general terms and conditions, this page opens up. And your lordship will not find anything pertaining to experience. Past experience, there's nothing.
yes.
Now, when we click on that page 78 service level agreement,
Ah,
page 182 open. At page 182,
yes,
at the very top, your lordship will see the heading service level agreement.
correct.
So now, there has to be what they say at page 78 is, if there is any contradiction between
Between
the
this one.
general terms and conditions with the service level agreement, the service level agreement
Will-
will override.
Yes,
Now, after having said this, they realize that this is going to fall through. Now the respondent number 3 has filed an affidavit.
why? Because service level agreement,
There
what
is
are,
nothing
nothing.
about your past experience.
Anyway, so anyway, this, those, clauses that you were mentioning at page 80 and page, 72, they are not, they're not,
Contradicting.
they're not, no, so they are neither general terms or conditions of the contract or, and they are neither the service level agreement.
Yeah.
Correct.
It is part of the NIT itself.
Part of the NID, it is
And-
not a part of the either of these two headings or.
And your lordship is aware, Raman now makes it very clear that once you have declared the norms, para
That
10
is
of
right.
Raman, once you have declared the norms, you are required to adhere to them. Now, after we filed it, after this was contested on the last occasion, now the respondent number 3 has come up with another interesting stand.
Respondent number 3 has filed. Okay.
Private.
Private. But respondent number 3 is a private, he's got nothing to say. Anyway, let us say.
Since they have taken over stand, it's my duty to point it out. What exactly they are trying to say.
Yes,
Now, they come up with another. If your lordship will kindly have their paragraph 3 at page, it starts at page 255. It continues, it's the longest paragraph. Your lordship will kindly turn to 256.
255, 256, but I don't have it.
It has been called today. so
Okay,
it might be
okay.
lying there.
Okay. Yes. Yes, para 3.
Para 3, it's a very long paragraph. I'm
Para
not talking,
3.
I'm just
Para,
placing the relevant portion.
para 3 at which page?
255.
255. Okay, yes,
If your lordship kindly turns over to page 256,
yes.
there is a paragraph starting further, clause 9.
For the clause 9, yes.
Further, clause 9 of general terms and conditions on GM so-and-so dated so-and-so has been misconstrued by the petitioner. Inasmuch as reference to service level agreement for supply of liquid medical oxygen would clarify the position as noted below. Preamble. If my lord allows me to pause here for a moment, and your lordship will kindly have page 182 of the petition together. So this is extracted from page 182 of the report.
Yes,
What it says is this. They have extracted verbatim this
Correct.
portion.
Ah.
Preamble. All supply of liquid medical oxygen service contracts placed through GM shall be governed by the following set of terms and conditions. General terms and conditions for goods and services. Service specific terms and conditions STC contained in this document. With reverse auction specific additional terms and conditions ATC as specified by the bidder. So specific general terms and conditions for goods and services, which is at page 130. Second is service specific terms and conditions contained in this document. So contained in page 182.
182, correct.
With reverse auction specific additional terms and conditions as specified by the buyer. And what will take precedence of this? The above terms and conditions are in reverse order of precedence. That is, ATC supersedes specific terms and conditions which supersede GTC. Wherever there are any conflicting provisions.
Correct.
So first condition is there have to be some conflicting provision. And in case there is a conflicting provision, the bidder specific terms and conditions, which are obviously in the NIT, not in the STC or the, not in page 130 or 182. That will take precedence over the general terms and conditions and the service level.
The bid will take
Bid will
precedence.
take precedence. Now,
Bid, what do you mean by bid?
with the NIT conditions
So the NIT condition, so
will always prevail
if it always prevails that it is against him, then
against him. But they are now trying to say that clause 4 falls within general terms and conditions. And clause 4 at page 70,
172.
172, no, page 72. Clause 4 is at page
72, 73, and that falls at page 80, the other one.
Page 80 is a specific term and page 73 is a general term. So therefore, the specific term will prevail.
No, specific term or service, that's a service specific term.
So now what they want to say, two things your lordship will have to hold to accept that argument. Number one, that there is a contradiction. A plain reading shows that one is a eligibility condition. The other one is an assessment of his.
No, but where do they say in their affidavit
Here,
that,
if your lordship continues to read this, they quote this portion and after that, page 257.
257, yes?
In view of the above,
Yes,
in view of the above, what is clearly evident is that in case of any conflict between GTC, STC, the STC will prevail.
correct?
That being the position, it cannot be gainsaid that the literal non-compliance of clause 9 of GTC would vitiate the award of the contract in favor of the respondent. They are firstly, they are admitting that they have not complied.
What is this clause 9?
This one. Page 139. So what they are referring to.
You have to know because you have to explain to me.
There is no clause 9 in the NIT. Clause Roman capital 9, your lordship.
No, no, it's not in the NIT, it's in the general terms and conditions. So just look at general terms and conditions.
General
It is
terms
at
and
page
conditions.
130. Starts at 130, so clause 9 will be, I think, that page 141, is it? No, this is 49, sorry. Clause 9 will be. And the problem is they've used the Roman numerical here.
There is no capital Roman 9 anywhere in the NIT.
At page 156, there is the GTC is there, integrity pact. That is with regard to indulging in corrupt practices.
Nothing.
So I do not know what clause 9. Anyway, we'll ask them that.
This is They are part, I don't know what they are referring to. Clause 139, there is a Roman 9, but that is a small Roman 9.
That is small Roman 9. The one, that small Roman 9, there enough small Roman 9. 141 also there's small Roman 9.
So I don't know what they are even trying to say, because firstly, they will have to, it is their responsibility to show that there is a contradiction between page 80 and page 73. There is no contradiction.
Okay, then what else? What else?
So-
Besides that?
There is another, once these two affidavits got filed, we had said, if your lordship, we have annexed the private respondents tender documents,
Then
which are
the
available in the public domain. Your lordship will kindly come to his NIT,
page.
his bill at page. Just give me one. Page 90.
92. Yes.
Along with his bid, he has enclosed some supporting documents. That list of documents is at page 90. He has stated, and this document is not disputed. This is his own tender. Your lordship will not find mention of any experience certificate. And we have annexed his entire bid. He has not disputed it. It does not include any experience.
Anything else?
Now, when the government filed the affidavit, they said that they have annexed. Your lordship will find that statement at page 192.
R2's affidavit. R2's affidavit.
R2 affidavit,
At para.
para 3, within brackets, Roman 3, page 192. The statement made is like this.
Yes.
That consequently, Messrs. Meghalaya Oxygen Private Limited, respondent number 3, fulfills the eligibility criteria mentioned in the scope of work and has been technically qualified. And in this regard, respondent number 3 submitted requisite supporting documents in order to fulfill the criteria prescribed in clause 3. And thereafter he says, copies of the past experience of Messrs. Meghalaya so and so is annexed herewith and marked as annexure C college. That C colleague, your lordship will find, it starts at page 211. Very interestingly, the deponent has sworn this affidavit.
C collie is at page.
Page starts at page 211.
Yes.
And if your lordship comes to page 193,
Just
your
a minute.
lordship will find
Ah.
that this particular paragraph has been sworn as true to knowledge.
So it should have been.
It, which means it is, we don't know. And the reason I'm pointing this out, there is a relevance. Where is the knowledge, question of knowledge of an officer regarding a tender document? There is a reason why it is sworn true to knowledge. Your lordship will kindly come to page 211. Each of these documents, I will point out.
Yes.
Page 211, it is by Nazareth Hospital, Shillong. This is one of the documents he has submitted as experience certificate. Your lordship will find that there is not even a date. And there is no mention in any, of any quantity.
Yes.
Now your lordship will kindly turn to the next page.
Ah.
This is not, this is a document which is not even on a printed stationery. No date, one thing. And again, no mention of any quantity.
Yes.
It is like those fake colleges in Bihar. Now, page 230. This is a consignee receipt and acceptance certificate. Your lottery will kindly see the prices are redacted.
Prices are?
Redacted. They have tactfully been covered. And
How do you spell redacted?
REDACTED.
Yes. Yes. So they are so they're covered. So what happens?
So either he has submitted the respondent number, he has submitted like this. If he has submitted like this, they don't even know the extent of supply he has made. Or it has been subsequently redacted, which means there has been manipulation of records. Now your lordship will kindly turn the page. The next certificate, it is not even a certificate. This is experience, Popu Enterprise. And he is supplying to some dealer.
So what is the connection between Popu and the respondent number 3?
Popu has placed an order to the respondent number 3 for some medical.
Popu is not a hospital.
Not a hospital. He is a dealer. And again, your lordship will find the price is redacted. Both unit price total and down below subtotal, total IGST, etc., all redacted. And your lordship will kindly see the quantity, only 5,000 kg. Similar is the position in page 215.
Okay.
Page 215, page 216. Just a
Yes.
quick glance will show that here also prices are redacted. These are supply orders.
Okay, so
And
that's all.
just 2 more pages, madam.
Yes.
217 and 219. Again, your lordship will not find mention of any quantity or the extent, the financial extent of the supply. 217 and 218. Now, this is something I had pointed out to your lordship on the last occasion. And yesterday, the respondent number 3 files had happened.
Yes.
The affidavit of the respondent number 3 starts at page 253. Your lordship will kindly turn to page 258.
And page 253, additional affidavit
No, affidavit in opposition.
of R3.
R3.
Yes.
Your lordship will kindly take up page 258. This is part of para 3.
Yes. Yes.
In compliance of the aforesaid clause, the deponent, along with his bid, submitted documents which demonstrate that it had supplied LMO to government so-and-so hospitals bed or more, which is the requirement as per the technical specification for supply of so-and-so. The buyer, being satisfied with the requisite documents, has decided to adjudge the deponent as Alma. Needless to say that in a proceeding under 226 of the Constitution of India, the petitioner cannot expect the Honorable Court to make a roving inquiry. And copies of the certificates of supply orders, etc., submitted by the respondent number 3 are annexed A series. Now your lordship will kindly turn to A series, page 267 onwards.
Yes.
Substantially the same documents.
What do you substantial? Is it the same or what?
That is the fun. That is the fun. I'll point out the difference. Manoj will kindly come to page 271. He states on oath that these are the documents submitted to the
Authorities.
authorities. Page 271. And your lordship will have it simultaneously with page 216 of the government act.
Okay, out here all the things are,
So
all the amounts are given.
at what stage did the manipulation take place? And these documents are not mentioned in the list of documents.
Ah, yes.
So were they inserted later on? At what stage did you insert? Is this the extent of, is this how you are settling liquid medical oxygen, playing with the lives of the people of the state? And your lordship will kindly turn to the next page. Poco Enterprise.
Just a minute, just a minute. At page 272.
272. The
Yes.
reason it was redacted by the authorities will also come out from page 272. This is, your lordship will have it simultaneously with page 214 of the government act.
215.
214.
How can it be 214? At 214.
It's the same as 214. In the
Okay.
government affidavit, this is redacted.
Ah,
In the private respondent's affidavit, it is not.
ah.
Now, because I have pointed out on the last occasion, they tried to improve upon the case. But in the process, what has come out is, your lordship will look at the amount, 1,25,000.
Where?
Poco Enterprises,
Ah, Popo Enterprise.
one,
1,25,000.
1,25,000. I am sure my learned friend, Mr. Kenshore's fees is more than this.
That's a,
1,25,000,
that's a different issue.
he is supplying, he is showing credentials for 6,955 metric tons. His credentials are 1,25,000 words. And your lordship will kindly turn the page to the next page. This is similar to page 250.
273.
273 is identical to 250.
Again.
Now redacted in 250 and here 273. That is why both the respondents have sworn that paragraph 2 to knowledge. Because there is something fishy going on. Otherwise, it is these are all matters of record. He has already submitted it. Your lordship will kindly have a look at both the affidavits. Last paragraph. These paragraphs are sworn to knowledge. Now,
This also is, what about this? This is true to knowledge.
yes. This is paragraph 3.
Ah.
And your lordship will see how they have sworn it. Paragraph 3 is true to knowledge. Sorry, paragraph 3 is true to records.
True to record.
If it is true to records,
Then
which one has been manipulated? One of them is manipulated.
just a minute. Affidavit at page 265 says
I'm sorry,
True.
but both are sworn true to records.
no.
Both are
Both
sworn
true to records. Okay.
So if it is true to records, one of them is a manipulated record.
Ah, true. Yes. No. 3-1, 3-2, 3-3, 3-1.
This
What
is
is this?
3-3,
No. Come to page 193.
193. Oh, here interesting, government affidavit, they have sworn
True to my knowledge and belief
knowledge as
and
well as it.
which I
Particular
believe to
partly.
be true. So that's what I'm saying.
It does not say partly.
Affidavit is true to
Government
record
affidavit, it is true to knowledge also, true to
Uh,
record also.
and at page
Private
193.
respondent affidavit, it is true to record. So if we assume that the respondent number 3 is telling the truth. Some government officer manipulated the records.
Or both,
Or
or both.
now,
Anyway, just a minute. I just want to see something else.
there is more to it.
No, just a minute. Okay, then
Now, for a moment, assuming but not admitting, we accept their contention to be correct. Let us go back to page 80, the relevant clause.
page 80.
That clause 3,
Huh.
and they are saying that that is the all-encompassing overriding clause. Let us take it on its face value for a moment, which cannot be, but I am for a moment trying to take it on face value.
Yes.
Let us read that clause once again. The bidder must have experience of supplying minimum one government or private.
Of
hospital
minimum
or
300 beds.
300 beds. They should have experience in supply of LMO. Now, next, supporting copies of supply order or contract or approved price list with your lordship will kindly mark with satisfactory completion performance certificate or any other documents in support of this must be provided. So you not only have to give copy of a supply order or a contract or a approved price list with satisfactory completion certificate. Now, if your lordship will kindly come to page 226 of our affidavit in reply, we have prepared a chart of the documents he has submitted. Where he has submitted a completion certificate, he has not submitted the supply order. Where he has submitted a supply order, he has not submitted a. For Popu, there is no completion certificate. For Nazareth, there is no supply order. We have given it in the to make it easier for your lordship. We have prepared a chart at page 226.
Yes.
Page 226. These are the certificates he has submitted. In respect of Nazareth, he has not supplied any supply order, contract, approved price list, but he has only submitted a completion certificate. In respect of 5A hospital, supply order not an only certificate. 151 base hospital submitted this supply order, but completion certificate not there. This is the position. And your lordship will find, I don't know what is happening in their reply. Government of India. I was finding it slightly interesting. In the certificates, it starts from page 211 to page 218.
Certificates of what?
Certificates purportedly submitted by the respondent number 3. Page 211 to page 218. So it makes it 8 numbers of certificates.
Correct.
In the respondents, it starts from 267 to 273. There are only 7 documents.
This page 263, this has been submitted by R2.
267.
260, no, 267 to 73. That is by
the
R3.
R3.
R3. No, I mean this 211 to 18 is R2's affidavit.
R2 is available. So there are 8 numbers of documents purportedly submitted by the respondent number 3. And in the respondent number 3's affidavit,
They might have mistakenly missed out one.
I am giving them the benefit of that. Now, while all this is going, your lordship, they made a specific prayer on the last occasion that they will file their affidavit by Monday, which they did not. They filed it yesterday, 3:30. But interestingly, one very important fact has been conveniently suppressed. They very proudly say that we have been given supply orders by different colleges from 16, and we are going on supply. This is the consequence. Page 296. We have filed a reply. Within a matter of 10 days, he has already been asked to show cause. That is exactly what our case was. That he is incompetent, he is incapable of supply.
Just a minute, page 296.
Page 296. What should you kindly? Where was the language? This is dated 26/7/2024.
Show cause notice.
That is why one should not be in too much of a hurry. Your lordship will kindly peruse the language.
This is to R3
Asked
by
by the
respondent.
Superintendent, Guwahati Medical College. Within 10 days, this is the fate of medical oxygen in the state.
Eh,
Whereas it has come to the notice of the undersigned that Meghalaya Oxygen Private Limited has repeatedly failed to fulfill the contractual obligation regarding the timely and adequate supply of liquid medical oxygen and nitrous oxide to Guwahati Medical College and Hospital. And whereas there are multiple instances of inadequate supply. One notable example is so as of 12 p.m. on 26 July, LMO shortage, 20 kiloliters LMO unit near the orthopedics department had a storage level of only so and so. Next, nitrous oxide, etc. And whereas the inadequate and delayed supply of LMO and nitrous oxide has serious implications for patient safety and overall operation of Guwahati Medical College Hospital, which can lead to disruption of critical medical procedures.
Anyway, so this is there.
So
So that they will answer.
they will ask. Now, if they have a clause, your lordship will kindly. There is a clause inserted in the NIT that if the L2 is not able to supply at the L1 rates,
Eh,
you will be penalized to the extent of blacklisting. Why haven't you blacklisted him so far?
If L1, you mean?
Your lordship will kindly come to page 80. It is virtually arm twisting, blackmailing, everything rolled into one. Page 80. Clause 10.
Yes.
What they do is since they have relaxed all the conditions, they are aware of the fact that he is not going to be able to supply. And what condition they put in the NIT your lordship? During emergencies, such as pandemics, it is mandatory for participating bidders to promptly supply liquid medical oxygen to any of the medical colleges of Assam. This must be done at the approved L1 rates. Failure to comply with this requirement will result in the bidder being blacklisted and barred from taking part in bid.
There'll be a show cause notice has to be issued to you.
Yes,
That-
so much notice has to be issued. But
To you.
what they are saying is, even I may be compelled.
I know, they're trying that.
Is
No,
that-
that can be taken care of at the time when that issue arises.
Yes, true. Now, my lord,
Right now, that issue is not there.
coming to the First submission, first limb of my submission. Firstly, there is no
So,
contradiction.
because, so
On
that,
facts, I have-
that is out no use. Yes, now yes,
On facts, I have, my lord, completed.
yes.
On the questions of law, firstly, my lord, my first submission is, there is no contradiction between clause 3 at page 80 and clause 4 at page 73. So that confusion that is being sought to be created, one is a basic eligibility criteria. The clause 3 at page 80 is a basic eligibility criteria. And clause 4 at page 73 is meant for determining the extent of similar services.
Clause 3 is a,
Basic eligibility criteria. And clause 4 at page 73 is to determine whether a tenderer has done work of similar nature and the extent to which he has done.
whether he has the experience required, I think.
And the extent also matters.
The
Like
extent,
for- Because your lordship is aware, in, let's say, a road contract, road construction contract. Similar clauses are there that you have to have executed a similar nature work to the extent of 80%, to the extent of 70%. Those clauses are there to find, assuming one contractor has made a small gully and he is tendering for a big national highway of 30 kilometers. Will the contract be given to that person who has constructed a small lane of 50 meters? So that extent has to be assessed. And that is what Ronak says, I'll place the judge.
you mean that judgment?
So the first argument submission is that there is no contradiction whatsoever. So there is no question of one overriding the other. And the requirement of assessing the past similar past experience is a mandate of law as laid down in Ronak. Your lordship will kindly come to Ronak at para 9. Please, yes.
Citation
99 1 SCC 490.
1999
1 SCC 490.
490
492.
49. Para?
Para 9. All the relevant parameters.
How many judgments are you giving me? How many judgments are you giving me? Yes.
I won't trouble your lordship with unnecessary.
Hopefully, the other side will also limit. Okay,
I am relying on paragraph 9, 10, and 11.
yes,
The parameters have been laid down in front.
okay.
The award of a contract,
Yes,
the award of a contract, whether it is by a private party or by a public body or the state, is essentially a commercial transaction. In arriving at a commercial decision, considerations which are of paramount importance are commercial considerations, which would be, we are not concerned with 1 and 2. But 2 also to some extent, whether the goods or services offered are of requisite specification. 3 is most important. Whether the person tendering has the ability to deliver the goods or services as per specification. When large works contracts involving engagement of substantial manpower or requiring specific skills are to be offered, the financial ability of the tenderer to fulfill the requirement.
4 is important.
4 is most important. The ability of the tenderer to deliver goods or services or to do the work of requisite standard and quality. And 5, directly on the issue. Past experience of the tenderer and whether he has successfully completed similar work earlier. How will they assess similar work? Unless they quantify. Otherwise, anyone would come, assuming clause 4 was not there. For a moment, hypothetically, let us assume that clause 4 at 73 is not there. Anyone who has supplied even 1 liter, 1 kilogram of liquid medical oxygen to a 300-bed hospital will qualify. If we, for a moment, completely obligate.
Okay,
Now, what the Supreme Court goes on to say further is paragraph 10 and 11. What are these elements of public use? Public money would be expended for the purposes of the contract. The goods or services which are being commissioned would be for a public purpose such as construction of roads, public buildings, power plants, or other public utilities. The public would be directly interested in the timely fulfillment of the contract so that the services become available to the public expeditiously. The public would also be interested in the quality of the work undertaken or goods supplied by the tenderer. Poor quality of work or goods can.
Okay, basically, yes, I got it.
Basically,
Yeah.
and paragraph 11,
The public interest.
paragraph 11, what it says, that a difference in price will not be important because quality also has to be ascertained and timely completion and competence of the bidder also has to be ascertained.
There must be some public interest involved.
And the next judgment I'm relying on is Ramana. Paragraph 10, just two sentences I'll read out.
Citation
79 3 SCC 489.
79 3 SCC for 489.
489. I am relying on a very small portion of paragraph 10, which is now a very, it has almost become biblical. Your Lordship will.
What about
and
Bhagavad?
paragraph 10 runs into almost 3-4 pages. I won't trouble your Lordship. Just one sentence, but
Yes,
at page 503,
503, yes,
paragraph 10,
yes,
that line about 10 from top.
Yes.
There is a sentence starting, it is well settled.
yes.
It is well settled rule of administrative law that an executive authority must be rigorously held to the standards by which it professes its actions to be judged. And it must scrupulously observe those standards on pain of invalidation of an act in violation of. Why I'm relying on this is you have declared a norm publicly that to be able to qualify in the technical bid, you will have to either fulfill 40% 3 words, 50% 2 words, 80% 1 word. You cannot deviate from this declared norm. Now, my lord, this so-called confusion has been sought to be created that this is general, this is special, this is this. I will place a judgment of the Supreme Court where under the same GM portal, what can we say?
Citation. You have this page, the photocopies, only this page. Only this, only this, only this.
This is 2022. 5 SCC. This is not for any proposition of law. I just wanted to point out that in the GM portal, how things happen. 2022 5 SCC 360.
Para?
Your Lordship will kindly turn to para 6. This is not for any other purpose, not for any proposition of law.
Yes, for my knowledge.
For in GM portals, how things happen. This was a GM tender.
Yes,
This was by Navodaya Vidyalaya Samiti.
yes,
If your Lordship kindly takes first sentence of paragraph 6, that number will show that it is on the GM portal. The dispute in the present appeals has its genesis in a notice inviting tender NIT bearing number GM public so and so so and so. This one indicates that this was also notified on the GM portal.
yes,
And a similar identical, your Lordship will find on the right hand side at page 369. Right in the middle, there is your Lordship will find serial number 3.
yes,
The bidder OEM themselves or through reseller should have executed project or supply and installation commission of same or similar category products during preceding 3 financial years. So and so, as on opening of the bid, as per following criteria. Single order of at least 35%, 2 orders of at least 20%, 3 orders of at least 15%. So, what? This is to assess similar execution of similar works. This is there. What they can change as per the requirement is the percentage. Here it is 35%. So far as 3 orders are concerned, it is 15% in this particular case before the Supreme Court. In our case, it is 40%. Here, 2
no,
orders.
these are there in
All
number of
tenders.
tenders.
So, and even in GM, this is the standard practice. Because otherwise, how will you assess a person's past experience? The extent of the past experience. There are, and we have annexed sample tenders where all those clauses are always there.
So those are there, some of them. So basically your case is that there is no contradiction between clause 3 and 4. And that, that's all. What else? What
And
else
he
is
does
there?
not, he does not meet. And secondly, even assuming we go strictly by clause 3, even then he does not meet, because in some cases he has submitted the supply order, in some cases he has submitted only.
And even as per the affidavit of the respondent number 3, the terms and conditions of the tender would supersede the general terms and condition and the service, whatever, that specific something, you know? I think that is just that.
So therefore, their technical qualification is expressly bad in law, that needs to be.
Okay, that's all?
That's all. So Lordship will kindly excuse me for.
My lord will kindly permit me to make my submission, then my lord will do.
Sure.
Yes, yes, because I am awaiting a matter in court number 1, my lord. Yes,
And then you've got another matter here also.
yes, yes, I'll come for that. My lord, in this case,
Ah,
now my learned friend has taken your lordships to 1947. We are actually in 2024. So even the event which is taking place in 2024, that is also not under challenge. Now let us first understand what is the prayer of the writ petitioner. Please come to the prayer portion.
yes,
My lord, first prayer number A, that technical bid evaluation should be set aside. Then mandamus should be given to give effect to the GM. Now C is very important at page 31.
yes,
A writ in the nature of mandamus shall not be issued, directing the respondent authorities to proceed with the tender process by evaluating the bids of the petitioner number 1 company as well as respondent number 3, strictly in accordance with all terms and conditions set forth in the tender document, including eligibility criteria set forth in the general terms and conditions and service level agreement for supply of so, and thereafter the tender process initiated by so be brought to its logical conclusion. Now, my lord, a repeated argument is being made. It is the general terms and conditions which will prevail, not anything else. That's why he is harping on page 73. Now, my lord, what is his prayer? His prayer is decide the eligibility in accordance with the general terms and conditions and the service level agreement for supply. Simultaneously, lordships will also take note of one thing: impugn NIT or any conditions thereof are not under challenge. His argument is, it is general terms and conditions will prevail, not anything else. So lordships will have to give a finding on that. It is his own case.
no, but then he was making submissions to the effect that the terms and conditions of the NIT will prevail, that's all. Not the general.
Then, my lord, then what meaning we give to this prayer? My learned friend is so technical about in particular, my lord, in Supreme Court, I have not seen this practice. We often make this, I have seen, my lord, everything is in knowledge. Well, there's a peculiar practice going on in this honorable court. Yes, in a civil litigation, when the matter of evidence comes, that can be relevant at sometimes. My lord, a deponent as a government officer, if he says he's true to his knowledge, yes, well, if he's called upon to testify, then it will be different aspect.
But what about the redacted, the blackened part of the
No,
document?
no, my lord, that I'll come, because in the bid, my lord, we have given the one. I'm having the copy of the bid. It was, my lord, the one which is annexed by the government. That is, even records will reveal, my lord.
Okay, you were saying impugned NIT. What were you saying about the impugned NIT?
What I'm saying is, my lord, we have got, now please come to, before appreciating my argument,
Yes.
please come to page 80 for a moment, my lord.
Yes. Yes.
We say, or rather the government say, that clause 3 at page 80 was taken note of while deciding the technical bid of the bidders.
Huh.
Am I clear, my lord? Kindly come to page 83.
Yes.
The bidder must have experience of supplying to minimum one government private hospital of minimum 300 or more bedded, they should have experience in supply of LM. Now, my learned friend's contention is in the earlier 10 some quantity was specified 30%, 40%, so and so and so forth. Now, in this NIT, that quantification is not done. That way, this NIT is not under challenge.
No, he says.
No, my lord, I'll come to that.
Ah.
What he's saying is, even if it says so, end of the day, it is general terms and conditions which will prevail.
Correct.
That is his case.
Correct.
Now, whether that is to be tested.
No, he says he's not challenging the NIT
Hmm.
because he says that this clause 3 in page 80 has to be read along with clause 4 at page 73.
Okay. Then, my lord,
That
to
is his case.
understand that, the lordships will kindly come to disclaimer of page 2. Then, my lord will kindly come to page 78.
Page 78.
Yes.
Yes.
So, my lord, let me complete that part. I was
Yes.
referring to page 80.
Yes.
My contention is the condition which the authority took note of, the clause number 3, and the condition which we understood, pursuant to which we submitted the bid was, the requirement is the bidder must have experience of supplying LMO to one hospital, be it government or private, where there must be 300 beds. There was no quantification regarding the quantity, as was there in the earlier NIT. It is to that extent my submission is, this clause 3 is not under challenge. All that he's trying to say is, this clause will not determine the evaluation criteria. It is the conditions contained in general terms and conditions will prevail. I'll prove, my lord, that is absolutely wrong. That is on the wrong understanding. Now, please come to page 78.
Yes.
The additional terms and conditions have been incorporated by the buyer after approval of the competent authority in buyer organization, where buyer organization is solely responsible for the impact of these clauses on bidding process, its outcome and consequence thereof, including an eccentrically restriction arising in the bidding process due to these ATCs and due to modification of the technical specification and or terms and conditions governing the bid. But this is important. If any clause is or incorporated by the buyer regarding the following, the bid and resultant contract shall be treated as null and void, and such bids may be cancelled by GM at any stage of the bidding process without any notice. In this regard, my learned friend drew your lordship's attention to clause number 12, whereby it was said, incorporating of any clause against MSME policy and preference to make in India policy. That means if you, if your bid contains any document or any credential which is against the policy of Make in India, then it is required to be treated as null and void. I'll come to this little later. First of all, let me come to the later portion. Now, if your lordship will kindly come to the last para, this bid is governed by general terms and conditions. Has your lordship got it, Miller?
Yes.
Stipulated in the bid and service level agreement specific to this contract as provided in the marketplace. However, in case if any condition specified in general terms and conditions is contradicted by conditions stipulated in the service level agreement, then it will override the conditions in the general terms and conditions. So if there is a conflict between general terms and conditions and the service level agreement, then it is this service level agreement which will prevail over the general terms and conditions. Now that is the understanding, our understanding. Now, my lord will kindly come to now, if your lordship will kindly come to the garments affidavit at page number 203, my lord. Sorry, 206. Huh? I think 182. Yes. No. Hi. Please come to 182 of the writ petition, Miller.
182 is writ petition.
Yes, yes, same document.
Yes.
All supply of liquid medical oxygen service contracts placed through GEM shall be governed by the following sets of terms and conditions. General terms and conditions for goods and services. Service specific terms and conditions contained in this document. 3. Bid reverse action specific additional terms and conditions as specified by the buyer. The above terms and conditions are in reverse order of preference. That is
Precedence.
precedence. ATC precedes service specific contract, which precedes GTC wherever there are conflicting provisions. This document represents special terms and conditions and service level agreement governing the contract between the buyer and the service provider. Purpose of this document is to outline the scope of the work, stakeholders' obligation, terms and conditions of all services governed as mutually understood by the stakeholders. So, my lord, after this, to make a advance and contention that it is the general terms and conditions which alone will determine the eligibility criteria, in my humble submission, cannot be correct.
No, but then you have got to show
Yes.
that there is a contradiction.
Yes, there is a contradiction.
Where is the
No,
contradiction?
there is a contradiction because, no, my lord, that's why I said this NIT is not under challenge. The requirement is
No, you see, his cases, I don't have to challenge the NIT because I don't see any contradiction. Now your case is that
No, my lord.
there is a
His-
contradiction.
Now,
So where is
let me
Yeah.
try to let me explain whether I have correctly understood his case, my lord. His case is be what may, page yes, 73, clause 3 has to be
clause 4? Page 73, clause
clause
4
4. Yes,
has
4.
to be read with
Huh.
clause 3 of page 80.
Yes.
So he says
Now,
that
my
there is
lord,
no
So
contradiction.
here is a case where there is a direct contradiction between page 73 and page 80
Okay.
and
So there-
182. There is a contradiction. Now, how to resolve this contradiction? And coupled with the law laid down by the Supreme Court, that it is the employer who is in a better position to understand the purport of a clause. And normally, lordships will give due deference to the employer's understanding
Correct.
unless it is blatantly perverse.
Correct.
In a given case, if somebody says black and white, certainly lordships will intervene. But whether it is dark or light, that aspect lordships will. That's why I say, my lord, a 226 code has its own limitation.
Correct.
Now, therefore, his case is come what may. It is clause 4 which will determine the eligibility.
No, it says both. It has to be read
No,
together.
my lord, there is no question of reading together.
So according to you, they are
It
separate.
cannot be read together.
So-
Either of one has to prevail.
So according to you,
Yes.
page 80, clause 3 will prevail.
Yes, because it is specifically provided in page 182
So
and the disclaimer.
clause 3 of page 80,
Yes.
according to you, is it a general term and condition of the contract or is it a service specific term and condition or whether it is a BID
No.
as per this page 182
Now
1A?
to further appreciate my contention, if your lordship kindly comes to page 73, towards down, there is a column scope of work. Scope of work, page 73.
Page 73.
Yes.
Yes. Page 73.
Now kindly see, when we go to this scope of work, then what we get is page 80.
Just a minute. Page 73, scope of work, where do you get?
73, Miller.
7.3, no?
Yes.
So there is 1, 2, 3, 4.
In fact, in
One,
the
two, three.
general terms and conditions itself,
No, at page 73, where is scope of work?
down below, towards the bottom, PDF.
The scope of work, yes.
There's a PDF.
Yes, yes.
Now this is available in page 79.
Is at page 79.
It
Yes,
continues up to page 80.
79.
Page 80.
Huh.
3.
Scope of work is at page 79.
Yes.
Continues till page 80.
Yes, it continues beyond that also, up to 81. Now kindly come to page 79. What is the
Yes.
heading?
Just a minute. Scope of work, where does it start from? Start from?
It starts from 79. Technical specification for supply of liquid medical oxygen.
Okay.
So the terms and condition is page 80.
Okay.
So my lord, there is no scope of reading it together. Either of one will prevail. Now, which one will prevail? The bid document itself says, in case of a conflict, the service level agreement that will prevail.
But
Yes,
if that is the case,
yes.
then
No, but if we do not succeed in, persuading your lordship.
no. I'm not on that.
No. What I'm saying is,
Uh-huh,
this is what the government has
I
understood.
just want a clarification
Yes.
with regard to your submission.
Yes,
As per this page 78 at the bottom,
73.
78.
Oh, one second. Yes.
If there is a conflict
Ah.
between general terms and conditions
Ah,
and the specific and the service level agreement,
ah,
then the service level agreement will prevail
yes,
over the general terms and conditions.
yes.
So now, which is the service level agreement?
Page 182. Page 182.
Page 182
Yes.
is the service level agreement. Now, service level agreement
Yes.
speaks of 1A, 1, 2, 3.
No, first one, kindly see, my lord.
Yes.
It includes preamble, all supply of liquid medical oxygen service contracts placed through GM shall be governed by following terms and conditions.
Yes. So it speaks of three things:
Yes.
GTC, STC, and
Yes.
ATC.
Yes.
Now,
No, service specific terms and conditions.
service specific terms and conditions there.
Yes.
But then there is another one also. There is also ATC.
Option, yes.
So
Additional
no,
terms and
okay. So according to you,
Yes.
this ATC does not come into the picture.
No.
So the only issue here is when
Yes.
there is a conflict between
No,
GTC and
it operates
STC.
in reverse order.
That is what. Now,
If it is
now-
a conflict between ATC and STC, ATC will prevail.
ATC will prevail.
Yes. If it is a conflict between STC and GTC, STC will prevail.
Correct. So now this clause at page 182
Yes.
seems to be in contradiction to page 80.
Page 80.
80. No, 78. 78 at the bottom. Is it?
No, my
What
lord.
is this service level agreement and this STC? What is the difference?
No, my lord. As far as I have understood, my lord, it is a service specific condition.
Okay.
For supply of liquid medical oxygen, there is a specific condition which is indicated at page 73 by that explaining that scope of work in so and so PDF.
So according to you, this page 73
Yes.
is a service specific term and condition.
Yes.
Okay, just a minute. Clause 4 of page 73
Yes.
is a service specific
No, my lord. Clause 4 is a part of the general conditions of contract.
Clause 4 is a general condition.
Yes.
Is-
And the
is- is-
specific
a-
is indicated in
ETC.
this PDF. In other words, it is in page 80. No, page 80.
Quite good. Okay, now if clause 4 of 73 is a general term and condition,
Yes. Yes.
clause 3 of page 80 will be what?
Clause
3 of page 80 will be what?
specific work specific terms and conditions.
Will it come? It will come
Yes,
under.
which is explained in page 182B.
It will come under
That is my
service
understanding, my lord.
service
That may be-
specific
Yes, yes.
terms and conditions.
Service specific terms and conditions. So there is a conflict. It is service specific condition which will prevail.
Okay.
That is my
So,
understanding,
so
my
there,
lord.
there is no
Because
ATC.
my
involved.
understanding
Is
will
it?
not matter.
Correct,
The
correct.
government's
No,
understanding.
but
will
I have
matter.
to.
Yes.
I have got
Yes,
to.
yes.
I need the help of you all to understand.
Certainly, certainly.
I am the one in the. I'm in the alley, blind man. You have got to show me the
Yes,
the
yes,
light.
yes, yes.
So according to you, ATC is not applicable in this. It does not come into the picture. ATC does not come into the picture.
Yes. So there is a service specific terms and condition which is reflected in page 80. And the evaluation was made based on that. That is my, as a private respondent, that is my understanding. Now that is the basic case.
Correct.
So his case is you should read it together. I said no, either one. Now regarding that MSME aspect, my lord, that MSME that we have make in India aspect.
Ha. No, that is gone. That is gone. That is not relevant anymore.
No, even then, my lord, I'll just let me clarify.
No,
that
because
position.
in the latest tender, which there is that requirement is not there. That is that make in India issue
Okay,
is not there anymore.
Then it's okay.
Mr. Indranil, that make in India issue is not there anymore in the latest tender.
Yes.
Ah,
No, there's nothing like it. My lord, my learned friend is trying to give an impression. End of the day, my lord, state of Assam faced lot of problem during COVID. So there was lack of oxygen also. It was during that time, this particular plant was set up in Bhutan. Why it was set up in Bhutan, my lord? I'm just giving it a copy, handing over a copy. Yes. Now, in fact, my lord, government of India has clarified that it is not required. Kindly have a look at this.
make in India.
Yes, it will not come in the way. I am directed to refer to the application of Meghalaya Oxygen, that is the respondent number 3, for registration under Department of Expenditure OM dated 23rd of July 2020, and to say that as per details provided in the application, bidder Meghalaya so-and-so and the manufacturer are India and Bhutan-based entities respectively. It is also informed that the subject order does not apply to entities based in countries to which Government of India has extended line of credit, development grant projects. Further, Bhutan is one of the countries where development grant projects are undertaken under Department of Expenditure order dated so-and-so. So since it shares the land border with the country and we are extending financial help and all, therefore that limitation will not, restriction will not apply. To make the things clear, me not. Then another aspect which my learned friend was harping. Oh, am I? My lord, to this extent, in para 3 of our affidavit, we have taken the position. Page 255. What I have argued, my lord, we have also indicated in para 3 at page
Yeah,
255.
para 3 is very long.
No, I'll not read the whole thing, my lord. That before adverting to the contents of the one second, page 255.
Yes.
That before adverting to the contents of the writ petition parawise the answering deponent would like to humbly submit the following in response to the submission made by the petitioner before the Honorable Court on 24/7/24 regarding non-uploading of the work order in GM portal and allegation of non-compliance of the tender conditions. This was one of the points. That it appears that non-uploading of work order in GM appears to be past practice of the department. As admittedly on last occasion, also when the petitioner was awarded the contract, the work order was not uploaded. Therefore, the argument that non-uploading of the work order in GM portal is fatal is misconceived. Further, clause 9 of the general terms and conditions GM 40 dated has been misconstrued by the petitioner in as much as reference to service level agreement for supply of liquid oxygen would clarify the position. So we have taken this 10 minutes. Then if your lordship will kindly come to page 257. After the quotation, in view of what is clearly evident is that in case of any conflict between GTC and STC, STC will prevail. That being the position, it cannot be gainsaid that literal non-compliance of clause 9 of GTC would vitiate the award of the contract in favor of the respondent number 3.
Just show, what is this clause 9 of GTC?
Yes, we have quoted me, Lord. I do. Page 182.
Page 182.
Yes. Page 182. Yeah. Just now what we read.
No, clause, no, where?
On top, my lord. Page 182.
It says,
One,
no,
one second. ठीक है सर? हम्म। तो 94 also government certificate good. One second. Clause 9 को भूल के बोलूं मैं कि हम्म हम्म into 1 second. 31/1/24 to code. Hmm? Right, 31/1/25. Yes, 5. One second, 1 second. 5. Clause Roman 9, na? No, no. No, my lord, when we say they misconstrued I was referring to page 139.
No, so this at page 257,
Yes,
this non-compliance of clause 9 of GTC
yes.
refers to which page?
Page 139.
139.
Yes.
Let us see 139. There is no clause 9.
Oh, my lord, argument was advanced by my learned friend that since the work order was not uploaded, therefore it
No,
vitiates.
no, I'm not on that. I'm not on that. No, just a minute. I'm not on that. Since you have said
Yes.
out here very
Yes.
clearly
Hmm.
that non-compliance of clause
No,
9.
this
I want
reply-
to see what is this
No,
clause 9.
this reply is in the context of the submission made by my learned friend that since the work order was not uploaded,
Huh.
therefore it attracts the vice of clause 9 of this 31-124. It is in that context. Because if your lordship will kindly see
No, but
the sentence preceded by,
just show
no,
me
I'm
this clause.
clarifying it.
Yeah.
That before adverting to this so and so, the answerer would like to humbly submit the following in response to the submission made by the petitioner before this honorable court on 24/7 regarding non-uploading of the work order in GM portal. It is in that context.
No, it's okay.
Yes.
But what is this clause 9 of GTC? I just want to know for my knowledge.
This is this one, my lord.
Which
At
one?
page 139.
139 of the writ petition.
Yes, yes.
139.
Yes.
Buyers are not allowed to place any order at GM prices outside GM.
Uh,
The prices on GM are only applicable if the procurement is made through GM portal.
that was the argument he advanced, my lord. That's why I'm referring to his argument of the date. Whatever was the context, we don't know. You were challenging the award of the contract. It was in that context this
Well, the buyers
argument
are
was made.
Buyers are not allowed to place any offline contract to the
His
seller.
argument was the fact that it was not uploaded, that itself is a good reason to interfere in the matter. That was his argument. That's why we say, that's why we made the submission, averments.
So this clause 9 that you're saying GTC
Yes, this
refers to, this is
Huh?
39.
Huh.
This is not 9 as per se.
139, my lord.
Page 139 of the,
Roman 9,
page 139.
yes, on top, Roman 9.
You see, there is a 9 even in clause 4. This is clause 3.9. This is clause 4.9. There are so
Oh,
many.
no, we are referring to page 139. Because that was what my learned friend read out. Oh, but some typographical error could be, but we are referring to this.
You're referring to this where it
Roman
starts at?
9,
Huh.
Roman
It
9,
says what?
where it says, my lord, there is a requirement of uploading the work order in the
No,
GM.
please read that Roman 9.
Buyers are not allowed to place any order at GM price outside GM. That's what was argued, my lord.
Is it? I don't know.
Yes, I think the video recording will reveal.
The lordship will kindly come to their own evidence. Paragraph 3. First, at page 256,
Yeah.
they say, further clause 9 of general terms and conditions on so and so has been response to
Yes.
the petitioner in as much as reference to the service level agreement for supply of liquid medical oxygen would clarify the position as noted below. Preamble, all supply data. This is about the precedence. And then next paragraph, in view of the above, what is clearly evident is that in case of any conflict between so and so will prevail. That being the position, it cannot be gainsaid that literal non-compliance of clause 9 of so and so will vitiate the award. What is the context?
That is what I'm still.
My lord, what in this paragraph we have dealt with what my learned friend argued the other day. His basic three arguments on the other day was that it is the general terms and conditions which will govern the criteria.
Correct.
Number two, he said that since the with my learned friend made that argument, now why is he shying away from that?
Look, those arguments are not in writing.
So, my lord, he argued that because it was not uploaded in the portal, therefore that itself is a good reason why it should be interfered with.
Okay.
Therefore, what are the two cases?
Since the work order was not issued.
His two cases were that
So,
we have
yeah,
no experience.
No. So only thing, when you
Yes.
say clause 9 of GTC here, you see this page 139, the clause 9 you're talking about,
No, it
it
is under the heading GTC, my lord.
it is under the heading GTC.
Yes, at page
Okay.
Yes.
So this is- Okay.
Under the heading GTC.
Okay. GTC. But then, when you come to page 134,
Yes.
this is also under the heading of GTC.
Maybe.
No, no, so which clause 9 are you talking about? There's
No,
only,
no, my lord, since my learned friend was referring to this clause 9 because I have marked it, my lord. 139.
okay, so according to this
Yes,
method.
yes, that's only
Just-
for the limited purpose.
okay.
And regarding the
We'll
rest,
accept it, we'll accept that.
regarding the rest, lordship will find at page 180.
Okay, but that is not an issue here.
Yes. So now the issue is very simple. Now,
Okay, just a minute. It refers to, it refers to page 139
Roman
of
9.
WP. Refers to clause Roman 9 small. Out here it is big. You see, in your affidavit it is big. Out here it's small. Anyway,
Anyway, so my lord, therefore, the case has been structured on the basis, basically two. A favor was sought to be made to my client,
Correct.
our client.
number one there.
The facts which has preceded would show.
Uh-huh.
Number two, but my lord, those are not under challenge.
Correct. Those are gone. Those are done.
So now the what is to be decided is in terms of the NIT, which all are the conditions which will govern the
Correct.
parties.
So it's,
Now, whether it is the general conditions of contract as given in page 73 or it is, my lord, at page 80. My humble submission would be
page 80 is it's a service specific term and that will prevail over this
general terms and conditions.
general terms and conditions.
And because why in page 73
Because of the
also,
preamble.
while explaining what is the scope of the work, a PDF has been indicated. And when we open the PDF, we get page 80.
Okay.
Yes. Page 73 is scope of the work. It's clearly indicated. So when we open it, my lord, we get page 80. In fact, it starts at page 79. We get clause 3 in page 80 where it says all that is required is there must be an experience of supplying LMO to a hospital.
Okay, so that is the case basically.
To a second step. Now, my lord, question is, much has been said. End of the day, my lord, what is the legal case which has been made up? End of the day, my lord, merely because a legal point is made out, lordships will not interfere. He must make out a case where it must occasion a failure of justice. Now, I'll rely on one judgment of the
I
Supreme
thought you were not going to rely on any.
No, no.
Yeah.
Only one judgment, one paragraph. Open the now. One paragraph.
Yes, yes.
2023 SCC Online 1051.
Let's see. 1051. Yes.
Please come to para 26.
26.
In this case,
Yes.
the tendering authority, after due verification about non-operation of the bank account on so and so and so and so, due to the strike by the bank employees, had accepted the additional performance security on 17/3/21 and awarded the work to the appellant. It is a settled law by a long line of judgments that the owner or employer of the project, having authored the tender document, is the best person to understand
That
and
is
appreciate
Afghans
its
it is there.
requirements and interpret its document.
Correct.
It has
Correct.
been held that the Constitutional Court must defer to this understanding and appreciation of the tender document by the employer, unless there is a malafide or perversity in the understanding or appreciation. So referring to so and so. Now, end of the day, my lord, the matter boils down to what is the understanding of the buyer here with regard to the different clauses in the bid document. Now, the buyer feels that even if there are any contradiction between any conditions given in the bid document or in the service specific agreement, then it is the service specific agreement which has to prevail. Now, in my humble understanding, my lord, this is the basic understanding of the authority. That is how the documents which I have given in support of my credentials, my lord. That all that I have shown is that I am a person who has supplied LMO to hospital, be it government or private, having 300 bedded. That is the only requirement. There is no quantification of, my lord, quantity. Though the other side would like to say, read that requirement. So in this situation, my lord, unless a perversity or malafide is established, then, my lord, it will be very difficult for your lordships to answer the writ petition in favor of the petitioner. And I would respectfully submit there is none. Some bold statement does not constitute malafide, my lord. Now, you were, the other day, you were arguing regarding this point, regarding this clause 9. Now, you yourself got a work order last year
Because
when
that
it
was
was not uploaded.
That was not under DM. That is the problem. They don't understand the facts. They don't rely on the entire fact and make some vague statements. Earlier, NIT was not under DM. This
Anyway.
NIT is under
Okay,
DM.
okay.
Anyway, my lord, therefore, in my humble submission, it is a fit case which lordships will not interfere. Nothing has been made out, my lord. And lordships will maintain the order which has been passed by the authority.
Okay, there is one
Yes.
clarification I require.
Regarding the tender, that, my lord, that there's some discrepancy in the annexure.
No, that is one. Another is that with regard to, you see in page 78, it talks of the bid is governed by the general terms and conditions stipulated in bid and service level agreement. Now this word service level agreement.
That is page 182.
No.
Yes.
Page 182 talks about service specific terms and conditions.
No, my lord. On heading.
Acha, okay, heading.
Anyway, my lord, yesterday, lordship would recollect, I moved the case where I didn't even get a stay order. Where a company having 12,000 crore, my lord, credential, he was not preferred. The view lordship had taken was, why should you get all the work? End of the day, that is
No,
also against
the view was that the marks given was a subjective satisfaction.
No, my lord. To my lord, to arrive at a subjective satisfaction, there must be objective material. Supposing, my lord, the objective materials are not there, yes, lordship will not sit in appeal over the subjective satisfaction. But if your lordship finds there are no objective materials to arrive at that subjective satisfaction, then 226 court can certainly interfere, because then it will that will be in the realm. Anyway, you will get your time to reply. Don't jump. So therefore, my lord, my humble submission is it's a case where the petitioner is, my lord, blowing his trumpet without any substance. That's my humble submission. Yes, regarding the certificate, my lord, the bid which is submitted, these are there, my lord, I can hand over the bid which I have given. These are the ones which are reflected in the government affidavit. So there is no scope of any, manipulation, my lord, as my learned friend would like to content.
The lordship will just check those certificates, whether they are redacted or not.
Orange flag, my lord.
Your lordship will kindly
Orange flag.
if they are
And before that also.
if they are redacted, there was no objective material. Because they don't know the quantity, they don't know the price. So how did they arrive at that subject?
Just a minute, I'll just see.
My lord, my learned friend is proceeding in the basis, entire argument is based on that it is the general terms and conditions which should govern.
Correct.
That is not our case.
Correct.
Our case is, I must have experience of supplying to a 300-bed hospital. That's all. That's it. That clause is not under challenge. Even one, yes. Even one, because there is no requirement in the NIT. Yes.
Affidavit of respondent number 3.
Yes. No, what I am saying, my lord, it tallies with the government affidavit. Respondent number
No, I am looking at the affidavit of respondent number 3.
Yes.
And the document he's given me.
No, my lord, along with the bid, we submitted this. What is your lordship holding in the right hand?
You submitted this to the government,
Yes, and government assessed it based on that.
but there's redacted out here.
Whatever it is, my lord, it is there.
But then in your document, it is not redacted.
Yes. No, government has assessed based on what is.
In your affidavit,
It
it
is
is not
not there.
redacted. Here it is redacted. What is happening?
My lord, government has not assessed on my affidavit. Government has done it based on that bid document which are given as a whole. Mala, can I find out it is, I think, all are there, Miller. I think before that orange flag.
Okay, I'll see this.
Yes. Lordship can retain that is our bid, Miller. And Lordship can ask them to produce the record also. Record will be the same.
No, but one thing why is it that your document that you have submitted to court
Huh.
has nothing is redacted, but in the document that you submitted to the authorities, it is redacted.
My lord, our case is the bid document which I have submitted that I am placed before Lordship. Therefore, my lord, my stand would be the one which I submitted along with the bid. That is my document.
But what about the document that you have
Maybe-
submitted in the affidavit?
Maybe by inadvertence, my lord, it could have happened, but it's not our case. That the document which I have annexed to the affidavit, that was the part of the bid.
Okay.
It's the bid document which itself I have produced. That is our case.
Because if it is the document that you submitted to the government, if it's a redacted document, then on what basis did they make the?
Lord, that's what I'm trying to submit for your lordship's kind consideration. Please give me 1 minute time, my lord. If your lordship holds that it is the general terms and conditions which should govern the determination of technical bid, then petitioner is to be allowed.
I'm not on that.
No, this is my argument.
Yes.
Now, if your lordship will kindly come to page number 80 for a moment.
Yes.
That is what I've explained in my affidavit also.
Yes.
3. Bidder must have experience of supplying minimum one government private hospital of minimum 300 or more bedding. Let us stop here, my lord, try to understand. One of that experience criteria is that the bidder must have the experience of supplying LMO to a hospital, maybe a private hospital or government hospital, and it must be a 300 bedded hospital. Number 1. They should have experience in supplying LMO. So all that is required is we must have experience of supplying. Now, my lord, if your lordship kindly permits me, in my affidavit, I have clearly brought out this aspect. In the affidavit, at page 258.
Yes.
Page 258, my lord.
Yes.
On top,
Yes.
in compliance of the aforesaid clause, the deponent along with his bid submitted documents which demonstrate that it had supplied LMO to government hospital, private hospital of minimum 300 bed or more, which is the requirement as per the technical specification for supply of LMO. My lord, our understanding of that particular clause is there is a requirement to show that we are supplying LMO to a hospital which is 300 beds.
That's the only requirement.
That is how we proceeded. That is how I submitted bid. That is how the authority has accepted our bid. So that lordship will take a call whether his argument is right or our argument is right. That's my case. Yeah.
Well, again, I will start from the page 78. There is a disclaimer. May I clarify this part?
Yes, yes.
I will start from disclaimer. At the bottom, these bill
Yes,
This bid is governed by the general terms and conditions. Very specific, my lord. This bid is governed by the general terms and conditions. Conditions specified in the bid and service level agreement. So it will be the general terms and conditions, conditions specified in the bid and the service level agreement specified to the service as provided in the marketplace. However, in case of any conditions specified in the general terms and conditions is contradicted by the conditions stipulated in service level agreement, then it will override the condition in the general terms and conditions. Now, Lordship will see the general terms and conditions, which starts from page 130. May I read the introduction part, madam?
page
Page 130 of the writ petition.
130 is the general terms and conditions.
Yes, madam. It is 31st of January 2024.
General terms and conditions at page 130. Okay. Yes.
May I read the introduction?
Yes, yes.
This document is an electronic record published by the GM under the provision of the Information Technology Act 2000 and rules made thereunder, and shall act as a valid agreement between seller, service provider, and buyer. Further, the use of GEM portal for sale, purchase of goods, service, and the resulting contracts shall be governed by the following general terms and conditions, unless otherwise preceded by product, service specific special terms and conditions, that is STC, product track domain specific STC of particular service, including its SLA, that is service level agreement, and this is very important, bid reverse auction specific additional terms and conditions as applicable. Now, Lordship will see page 131.
Yes.
These are the definitions, my lord. Start from page, my lord, from clause 2.
Yes.
I will refer to C, services. At page 131.
Yes.
Services shall mean the services offered or provided by the seller, such as IT professional services, manpower services, security services, transport services, etc., listed as service on GM. The term service shall also include supply of goods, articles which are incidental and consequential to the provisioning of such services as defined in the scope of supply given in the contract. Now, my lord, G, seller.
Yes.
Seller, my lord, here I would like to, my lord, point out in the next page, this definition of seller continues in page 132.
Yes.
My lord, the last second para of this particular definition. In case of service, page 132.
Yes.
In case of services related to goods, service provider as GEM will be either OEM, that is the original equipment manufacturer, or the service provider having authorization to service products manufactured by that OEM in open market. In respect of other services, service provider of GEM will be any legal entity offering his
What do you mean by OEM?
original equipment manufacturer. Here it will be the Bhutan company, from whom the
Now you see one thing. Services, when you talk of service at page 131. Okay.
my lord.
Goods articles, okay. In case of service related to goods, service provider on Jim, the liable be the OEM. Also having
Service shall also include
Okay.
supply of goods. Here, my lord, the supply will be, my lord, medical liquid medical oxygen, my lord.
So is this it's manufactured in the open market?
My lord. No,
Is it
oxygen
open?
otherwise, my lord, not all products, my lord.
No,
Can't
please read in case of services, page 132.
The term service shall also include supply of goods, articles which are, my lord, the page 32,
Yes, 132. In case of
In
service,
case of services related to goods, service provider on GM will be either OEM or service provider having authorization to service products manufactured by that OEM in open market. In respect of other services, services provider on GM will be any legal entity offering its service. Now, my lord, next part is very important, my lord. By registering on GM portal, seller service provider hereby agrees to be bound by these general terms and conditions for sale, purchase of goods and or services, that is GTC, product service specific special terms and conditions, that is STC, and service level agreement for various services and, my lord, additional bid specific terms and conditions etc as applicable. For the purpose of this document and transaction on GM, seller as well as service provider will be referred to as seller. Now, Lordship will see page 133. Clause number, my lord, here the heading is, my lord, 3. Role and responsibilities and obligations of sellers and buyers. A, it is the role and responsibility of seller on GM. It continues, my lord. Next page 137 is the role and responsibility of buyer on GM. These are not very relevant for this case, so I am not referring to. Next, my lord, 138 is very relevant. Buyer's responsibility on GM portal are as under. Page 138.
Yes,
I will refer to, my lord, directly to, my lord, para 4, clause number 4.
yes.
While making procurement on GEM, the buyer shall judiciously search and shortlist items using filters such as quality, quantity, technical parameters, delivery period, warrant period, consignee's location, sellers eligibility, etc., as per their approved requirements. A placement of contract for a product service uploaded by the seller in any wrong or inappropriate product category is strictly so. Now, Lordship will turn to.
Take me to the relevant portion. We are
My lord, my-
reading out
Now, Lordship will see, my lord, page 143.
page 143.
Yes.
So these 138, how does it have any?
No, that no, my lord, I'm sorry, my lord, 143.
So 130 is of no use.
No use, my lord.
Then 133, what is 133? 133, how does it, how
No,
does it
that's
have
I'm pointing out. Well, 143
133
is 143.
role and responsibilities?
No.
How does it have any?
That's I'm
Relevancy.
saying, my lord, what is there in the general terms and conditions. Now, relevant will be 143.
So these are the general terms and conditions.
No,
Page 143.
yes, it is relevant, my lord. It is Roman, my lord, 13. E-bidding and reverse auction then. Because it is a e-bidding, my lord, e-bid process. This will be relevant 143.
Yes,
Now, I will refer to C.
see, yes,
The technical parameters and warranty of the item identified by the buyer shall be base parameters for items of conducting e-bid / RA for the required goods.
what is RA?
RA reverse bid, reverse auction.
Reverse something.
Yes. Now, my lord, next page, my lord, G. In bid document, buyers can incorporate suitable. This is very important, my lord. G. In the bid document, buyers can incorporate suitable eligibility criteria and additional terms and conditions only using various filters, etc. so and so, available in e-bidding RA modules of them. Buyers are not allowed to incorporate eligibility criteria and additional special terms and conditions exterior to the GEM portal by making reference to any other website.
How much time are you going to take?
Sometime.
Okay, we
Because I will
will
have
carry
to
on.
clarify that part, my lord.
Carry on, but then there are a lot of other matters. Anyway, we'll finish it this off. Oh, we have full bench at 2, it'll take just 5
Yeah.
minutes, then we'll finish. No, so what is your case? Does it come under general conditions of contact or
So,
specific
my lord, I am
service?
pointing out, my
Or
lord,
does
this
it come under
particular-
ATC? Which one?
Yes, my lord.
You're beating around the bush. First come
No,
to
my
the.
lord, I will have to, my lord, build my argument.
No,
That's why I'm
I'll,
referring.
but what are you trying to prove?
Yes, my lord, regarding this G at page 144,
Yes,
Roman 13 G at page
Yes.
144, it
Yes.
says it is a buyer, they can incorporate suitable
no,
conditions.
that's all right.
Yes,
That's
now, my
all
lord, now, Lordship will kindly turn to page 182,
182.
service level agreement.
Yes, this one I want.
May I read it? I will have to repeat it again.
Yes.
Preamble, my lord, says all supply of liquid medical oxygen service contracts placed before the GM shall be governed by the following sets of terms and conditions.
Yes.
One, it is a general terms and conditions. Service specific terms and conditions contained in the document. Third point, my lord, very important. B, reverse auction specific. Additional terms and conditions as specified by the buyer. Now, may I read further? B, the above terms and conditions are in reverse order of precedence. So ATC precedes service specific STC, which precedes GTC. Whenever there are any conflicting provision, this document represents the specific terms and conditions and the service level agreement governing the contract between the buyer and the so-and-so. The purpose of this document is to outline the scope of work. Lordship will kindly mark it, my lord. The purpose of this document is to outline the scope of work, stakeholders, obligation, and terms and conditions of all services covered by mutual so-and-so. Now, Lordship will see, my lord, point number 4. Service scope. 4.1, introduction. The supply of liquid medical oxygen service is demanded by the buyers as it is vital to ensure that the medical oxygen supply system so-and-so. Now, next, the scope of work. Now, my lord, since we are the buyer, my lord, we will be the authority who can, my lord, specify what is the scope of work. It is a general scope of
Correct.
work. So
Naturally.
that's why, my lord, that
Yes, that's
additional
your
terms
duty.
and conditions we have incorporated. Now, Lordship will turn to the main
No,
contract.
before that,
My lord.
just one simple question. At page 182,
Lordship.
the preamble
Yes,
speaks of three different types of terms and conditions.
my lord, my lord,
Okay, one is GTC, one is STC, and one is ATC.
Lordship.
Now, my question to you is that clause 4 of page 72,
That is the
73.
default clause we have stated, my lord, in affidavit.
So what is it? Does it come under STC, GTC, ATC, under what?
It comes under ATC. That's why
That
Lordship
comes
will
under-
kindly turn to
So
page
that
70.
is what I wanted to know.
Yes.
Okay.
My lord, what I, my lord, let me complete. my lord. Yes. Because, my lord, it is the, my lord, respondent fee who is not the, my lord,
no,
authority who has allotted the tender.
clause 4
My lord.
of page 73
Yes, my lord.
of the writ petition
Lordship.
comes under ATC.
No.
Comes under what?
It is a general condition, not a general in terms, my lord, in the ZEM portal itself, it is provided.
No.
But it is neither.
So whether it comes under GTC or STC or ATC, it does not come
No,
anywhere.
No, because,
It
my lord,
doesn't-
Lordship, I have placed the general terms and conditions.
So
is a
it does
part of
not
the
come
petition.
under any of this.
Yes, my lord. That's a default clause. That is the
Okay.
term used by us.
Okay.
That's why Lordship will kindly turn to again, my lord,
That
for
does,
page
does,
78.
does not come
Under
under the
neither
under the
DTC.
preamble.
Yes.
Under the
Under the
preamble.
preamble, my lord.
Under the preamble.
So one point again, my lord, page 78, just for a moment, my lord. Page
Yes.
78. In page 78, in the down below last para, I have mentioned, my lord. Here only, my lord, general terms and conditions and service level agreement has been mentioned. ATC is not there, my lord. May I point out, my lord?
Out here, what is mentioned is only
No, no.
service level agreement.
Yes.
Yes.
No. Two part, my lord. General terms and conditions and service level agreement.
Correct.
Yes. Now, my lord, going to page 182. 1/3, my lord, condition has come up. That is ATC.
No, and also service specific term who is not there in the page 78.
No, service level agreement, Lordship will say
No, this
182.
is this is service level.
Yes.
This is service specific. It's different.
No.
The words are different, Mr. Counselor. There's a thing called service specific and the thing that's called service level.
Service level agreement.
There is no
specific-
word specific in page 78.
My lord, I could not follow it. Service level agreement is there, my lord, 182.
182 in the top.
Yeah.
Service level agreement provides for GTC and for STC.
Yes, sir.
STC is not there in page 78.
78. That's why, my lord, point C, not point C of 182. 182, my lord, may I read it?
Anyway,
see.
anyway. Acha, there is one thing.
No, let me clarify it.
No, we'll take it up at 2.
Yes.
No time. You see, one thing is that Mr. K. Chaudhary was saying, with regard to that scope of work. Once you click on that, it starts from page 79. That's what he was saying.
Yes, it's there. It's,
Nothing
my
of,
lord,
nothing.
My lord,
of
one
all those
thing.
matters, for the simple reason. We are all proceeding on the basis that there is a contradiction. All these arguments will arise only if there is a contradiction. They have not been able to show where
My
is the
lord, first of
contradiction.
all, my lord, we are the authority who
Anyway,
issued the tender.
we will
We are
see.
the author of these terms and
Correct,
conditions.
correct.
So let
We
me
will-
clarify. Neither the petitioner is, my lord, is the one, my lord, who has uploaded it, nor the respondent number 3. So let me clarify, my lord. They have
Okay,
their own
at 2
interpretation.
o'clock, at 2.
Yes, sir.
Mr. Chaudhary, I think you must have gone through the High Court Bar Association, Allahabad. Case. Now there, of course, the four judges, I mean, the bench said that it was not necessary for the court to go into whether clause 3 of 26 was mandatory or directive. The majority decision. For the dissenting judge, while, taking his own judgment with regard to the fifth case, with regard to, whether the High Court could interfere with the framing of charge order, has held that, as it has said, it is worth noting that wherever under the statute any such time limit has been prescribed or is fixed for deciding a particular matter, nature of proceeding, it has held it has been held to be directly nature rather than mandate. So appears to be the position with regard to the applicability of Article 226 of the Constitution. That is what he has said. So, are we bound to follow it? This observation? Our single judge input. Which issue was not the issue needed to be considered, because the issue was whether charge framed by a Prevention of Corruption Act could be interfered with by the. So there might not one of the decision matters. The Supreme Court under Article 142 cannot pass an order directing automatic stay of the intent order order that are expiry of the 6 months. That observation was also there. No, that is there. That should have that's the direction path. Now here is a provision of the Constitution, not of some act, but of the Constitution.
Because those words are statute. Constitution can't be said to be a statute.
Statute is interpretation of the basis of the statute, as well as also with reference to the Constitution. The validity of the Constitution as it was original cannot be put to check. For example, as regards the validity of an amendment to the Constitution can only be challenged within the parameters given in Kesavada Dhamma, wherein it says that Article 368, which is also a basic feature of the there gets the plenary power given. It meant every except abrogate or destroy the contract or basic structure. So when an amendment is being made by 263, it is an amendment in exercise of the powers under 368. And if it is done under 368, that amendment is being done. The amendment has been tested on the basis of the basic structure. Now, is it ever conceivable that a provision of a constitution can take to be direct, taking into account, but may very well nullify a provision of a constitution on the basis of violates the basic structure? Or it may at best be read out or given a purported interpretation to the debate that it means actually indeed taking into account that the Constitution is a written document. But to have a concept that a provision of a constitution is directly
would be nullifying the constitution.
But I have to be clear, my lord, after any part of the constitution or any section that not been published. Only from the point of the interpretation of it. The purpose is,
But it cannot be said to be directly. One can very well give a proposal to the effect that what it actually mean, what it is fixed. Or for that matter, if you see the judgment of the Allahabad Bar Association of the study and paragraph C, it mentions that about 18 telling orders when by party. Don't you think the 226 form is that it only be applicable in respect of 18 telling orders? Yes, if we see that. And it is further mentioned that once it is an 18 heard by the other side, then it takes the flavor of an interim order.
I get your word.
Because, just a moment, just a moment, Mr. Chaudhary. I'm just adding to what my brother is saying. You see, if we try to interpret the constitutional provision by saying it is a directory or mandatory, tomorrow someone may come up with a concept that, okay, 5 years election is not mandatory. Let us have the election after 10 years. So that is the concept with which we are asking that question.
And there has to become context to the issue. Since it has the for procedure. Either we will have to decide whether the court can really go into this. Because actually might have to take either way.
You see, the judgment you have referred to, what is the Google diet, as well as the indoor judgment. Yes. These are judgments where the court was construing a provision of a statute and had said that shall be made. But here, how do you take that shall be made, putting that automatically violate the Article 14, where it means in some cases very well applied, so it's guided and it's prohibited in some cases. The word shall cannot be made a bit in the context of the
Madam, in fact, case law that this point of whether the case law on the basis of this point of view of possible to decide the parameters to keep the court.
But what about the observation made by the single judge of the Supreme Court in High Court Bar Station, Allahabad versus State of UP? Now, are we bound to follow it? The Supreme Court. It is a dissenting judgment. And though the issue was not with regard to 2 to 6 feet, he has made an observation.
Who has respect of my lord, taking anything from it.
He has not gone really deep into it. It's just that it is worth noting that wherever under the statute any such time limit has been prescribed or is fixed for deciding a particular nature of proceeding, it has been held to be directory in nature rather than mandatory. So appears to be the position with regard to the applicability of Article 226(3) of the Constitution of India. We'll take a call, but then I just want to know what is your view.
But I suggest that this is the ending of the offer.
You see, in the concept of section 34 of the Arbitration and Conciliation Act, it has been held that the time limit is not extendable.
Yes.
Therefore, when it comes to the statute, there is an interpretation that the time limit given is sacrosanct. Insofar as Commercial Courts Act is concerned, written statement not filed after 120 days. The same material provision of Order 821 has not been invoked. It has been negated, says that 120 it can't be extended. So even in cases of statutes, there has been interpretation by the Supreme Court where it says that the time limit given is sacrosanct.
Whatever I have to get my the truth from my that that more particularly in view of the Allahabad people part. That is my understanding.
Yeah, so the super judge, parasitic with the same judgment. I said that it is noticeable that under Article 260 of the Constitution of India, the automatic cessation of the stay order envisages making of an application to the High Court for the vacation of the interim stay order. Therefore, filing of an application for vacating the stay order is kind of one of for triggering the automatic cessation of the stay order. See, if such an application is not decided within the prescribed period of. So according to you, we should it should be taken to be directly. That's what
That is what I understand. You understand? I understand.
but the issue is whether we can say it is directly or mandatory.
You
But this is a constitution provision. So it is an amendment of 260.
I think that it cannot speak your worship more than what I already said.
So this question is in light of the another judgment of the Supreme Court, where it says, this is Municipal Corporation of Delhi versus Gurnam Kaur, reported in 1989, 1 SCC 101. Here it says, in paragraph 11, pronouncements of law which are not the part of the ratio decidendum are classed as obiter dicta and are not authoritative.
My position will be this particular observation is not obvious.
So this is by three-judge bench again. It's Municipal Corporation Delhi.
No, why I say in this Allahabad, I could not. This perhaps cannot be taken.
Okay.
Okay. It will hopefully we will be able to pass the order within 1-2 weeks.
But I am not sure whether I was able to get proper assistance there.
No, you have helped a lot. Only it's a very difficult question.
But we value what you have said.
I thought we'd have it after this, okay. Anyway. Right, on the prayer of the council for the party. It is the matter of. Okay.
That is from the. It's okay.
This is a hurry, this is a hurry.
Lottery will indicate the player of the parties.
The matter will take time. Probably will take time. It's a catering service. Again with Mr. Chaudhary.
Hello, there is not very regarding that specific to the service that is mentioned in the display. May I read this part? Page 78 for a moment.
78.
Yes. The disclaimer, that bottom part. The bid is governed by the general terms and conditions stipulated in the bid and service level agreement specific to the service.
Yes.
Now, what we turn to page 182.
182.
Yes. What you will see at the top pile, service level agreement for supply of liquid medical oxygen. So this is specific to the. So had it been a CT scan machine, it would have been supply of CT scan. Okay. So this is now regarding our power. Lord, you will see page 182 down below regarding the scope of work. Yes. Here, my lord, nothing has been provided except that, my lord, the concerned, my lord, seller, he will have to supply. But, my lord, to provide the specification and all, that power has been granted to us in the general terms and conditions. That I will point out, my lord, it got left out, only one para regarding that e-bid process. Page 143. Page 143. 143. Part of the general, no, general part, general terms and conditions. Page 143 of the district. Here, my lord, Roman 13B. Roman 13B. The e-bidding plus RA document will be finalized by the buyer. This page 143. Yes, sir. Yes. The e-bid RA document will be finalized by the buyer by stipulating requirements such as quantity, consignee details, terms of delivery, delivery period, bid security, performance security, time and date of to start and end of bid submission and for opening of bid and required bid validity period, etc. Jam system shall decide start, preference price and step value of decrement in case of RS based on product selection and on outcome of bidding process. Now, my lord, next page, my lord, G, 13G. In the bid document, the buyer can incorporate suitable eligibility criteria. Now, my lord, since, my lord, in the scope of work, the specification of this requirement, whatever we are procuring, since it is not there in this, my lord, special service level agreement, so we have issued that scope of work. Under, my lord, the authority at clause 3 of the preamble, Lord, make I see Roman 3, page 180. It says the bids reserve auction specific additional terms and conditions as specified by the buyer. So under this, my lord, we have given that particular eligibility criteria in the scope of work. The Lord will therefore turn to the scope of work. Page 79. It says, my lord, technical specifications for supply of liquid medical oxygen. This, my lord, this authority has been given under the, my lord, general terms and conditions, as well as the special leave agreement, special level agreement. Page 79. So, my lord, very page 79. This technical specification for supply of liquid medical oxygen, it starts, my lord, quantity per year, gas pressure, storage system, mode of measurement, everything is there. Now, in the next page, it doesn't this scope of work, it is this technical page 80 now, part of this page 80. Terms and conditions. So, additional terms and conditions we have incorporated. So, here, my lord, 3. The bidder must have experience of supplying to minimum one government private hospital. Now, what I want to, my lord, point out, this particular eligibility condition that we have incorporated is under additional terms and conditions. And it will no, but otherwise, my lord, these are the conditions that we have incorporated. Whatever conditions are here, it is here. This is additional terms and conditions. What is the original terms and conditions? General terms and conditions. The general terms. Then comes from the service level agreement. Then comes the additional terms and conditions. The general terms and conditions include that page 73 para clause 4. No. Just tell me, if page 80, well, if page 80 is the additional terms and conditions, what is the original terms and conditions? Well, it's the general terms and conditions. That's what I'm calling it. General terms and conditions. Which one is the general? Well, it starts from page 130. Because in the disclaimer, when we click the general terms and conditions, in the 130 is the general terms and conditions. Yes. Well, in the disclaimer, as has been pointed out by the petitioner, page 30 does not give any terms and conditions. That's why you have to give it, my lord. That's why you have to give it. It's upon the buyer always to give that, my lord, terms and conditions. So, page 30 is the additional terms and conditions. The original terms and conditions. Page 130. It's page 130. Yes. My lord, why I'm saying, my lord, general, my lord, JM is a, my lord, general platform for procuring, my lord, for every government department. But I understand, sir, well, that's why the buyer will keep his own conditions for procuring certain items. That's why if there is going to be an additional term and condition, there has to be an original term and condition. So this, it is like if you're going to file an additional affidavit, there has to be an earlier affidavit. Yes, new fact. So there are additional terms and conditions from the page 80. Yes. While the original terms from the page 80. Yes, in a sense, we have to take that these are the conditions which are already there. So this is the additional one under this ATC, additional condition set out by the buyer. So this will supersede everything. And so far as so far as page 73 clause 4 is concerned, what is this? 73(4). Well, this is a standard format that is there in the SAP portal. That's why I'm saying. That has been, that statement has been made by the petitioner themselves, but it remains, it's always there in depth. Clause 4 of page 73. Yeah, had there been no terms and conditions. Is a standard terms and conditions. It is there, well, yeah. Standard term and conditions. Just standard is remains. And conditions, which is always there. Yes, I cannot say, my lord, whether it will come under the general terms and conditions, because, my lord, it is a standard term. To be honest, my lord, I cannot make it. No. Okay. But yes, it's a standard term and conditions, which is always there. Always there. Which is always there. Because these options are there. It is always there in the gen portal. It remains. It is always there in the gen portal. Because that's why I said to be clear about, because later on you say I did not say this. No. So that's why I have to say clause 4 of page 73 is a standard term and condition which is always there in the tenders in the depot. The tenders in the depot. Correct? Well, that's what appears. So now, my lord, considering this, my lord, particular criteria at page 50, there was condition number 3. We have, my lord, evaluated the bid, and whatever documents that the respondents were attached in the affidavit in opposition from page 211, it was uploaded by the respondent number 3. We have verified that part, and it is still there. Since, my lord, the participating bidders, they have got the key to enter into the port. Nobody other party can. So they can always go there and check it, and they know that these are documents are there. Otherwise, they have already placed any other document if it is there. They would have placed it in the list. Today, what they have placed, I don't know, but for our part, my lord, whatever document was available, I have in this particular application. These are the documents. And verifying this, he was found to be a and as a L1. And today, my lord, so far as the rate is concerned, there is a big difference, my lord, the petitioner has subscribed. So we are gaining. That's a thing. But tomorrow, my lord, if he fails to supply, whatever penalties we face, there's a different issue. Not a part of this particular. No, you are gaining, no doubt. Yes, the issue is not whether, but the issue is not whether you are gaining or not. The only issue is whether he has got the eligibility criteria or not. As per our, my lord, evaluation, that kind of already we have found him to be eligible. And, my lord, regarding what that the expert case, my lord. It is, my lord, 2016 16 SCC 8 16 SCC 818. I will refer to one para 50. We may add that the yes. But it is there is the no, it's okay. We may add that the owner or the employer of the project having authored the tender document is the best person to understand and appreciate its requirements and interpret its document. The constitutional court must refer to this understanding and appreciation of the tender document unless there is malafide or perversity in the understanding. Already, yes. And one more, my lord, that ends the project. There also, my lord, same thing has been discussed. There are 12. So it's like saying I've got 1,000 witnesses, you have got only one or something like that. It is the same thing. So why should you? No, last time that one is there. How does it matter? So there, my lord, one thing has been stated that, my lord, they come to the court with the, my lord, there is ground and all. To delay the entire, to sabotage the entire process. That's what I. But I'm sure there is a. Yes. What is the cycle law?
2022. Para,
Para मतलब 12, 70. One more मतलब email public communication network private limited versus Union of India. Para 40. It is 2008, 16 and 215.
215.
Yes. Para 40 says मतलब if there is minor deviation of the terms and conditions, I'm not saying we have done it, even if it is there, it should be मतलब this public interest, should be over. It says मतलब honorable together. A contract is a commercial transaction and
If it is in public interest.
may I a contract is a commercial transaction and evaluating tenders and awarding contracts are essentially commercial functions. In such cases, retrieval of equity or natural justice plays a difference. If the decision relating to award of contract is bona fide and is in public interest, court will not exercise the power of difficulty to interfere, even if it is accepted for the sake of argument that there is a possibility. We are saving public money. But even then, my stand is, my lord,
At the end of the day, you might find out that you have taken an inferior quality. If you have issued so-called notice,
not inferior quality, my lord, he has failed to supply. That's a different issue. Quality is different.
okay, not quality, but you might have chosen the wrong guy.
Yes. That my lord may come.
Might
That,
have,
my lord,
might.
ultimately he will have to supply as per the.
We see that. But now there's one thing. At page 73, at the bottom, it says scope of work.
Yes, sir.
Now, when you click this scope of work, what happens?
Then my lord, this my lord, page 79 will come in.
Page 79.
This is part of the expedition. They know, my lord, and this particular my lord, technical specification has been given by the by the buyer under the power conferred under my lord, that service agreement clause 3 of the PM. Which supersedes my lord every other clause.
Okay, there is one aspect you are saying.
Yes.
That the issue of this general term, the PTC and all the PC and all the will come into play only when there is a contradiction between, or there is a contradiction between the various clauses of the
That I am contract. If it comes, my lord, then it will be ATC. Otherwise, my lord, ATC empowers the buyer to incorporate additional conditions. That's also one.
No, he's saying, and if there is no flag,
Yes. Then also ATC under ATC the buyer can keep.
no, but if there is no flag, is page 182 the preamble, does it can strictly apply? Is there any reason for application of the preamble when there is no flag between the different provisions of the contract?
Yes, madam. This says that's why I'm saying, well, in the disclaimer there is only two conditions. One is general condition, and there is my lord service level specific condition. In my lord service level specific condition under the preamble part, the clause 3 of the preamble says that the buyer can now incorporate. So currently one power has been given to us.
No. Okay, it is at page 80, page 80, according to the additional term and condition. Agreed, it is the additional term. Now, where is the contradiction? I mean, okay, so according to you, so because the requirement of that percentage.
Yes.
So you say there's no requirement of.
Not required. If at all they are saying, then it will supersede the committee. If at all they say that this is have to be followed, our my lord counter will be it supersedes the committee. Because it is ATC. It is above my lord service level agreement as well as my lord general.
So this page 73, that the clauses therein have no value.
My lord, as per our it's the default clause that we have, that's why it is not considered.
It is not,
we have given our own
relevant according to you.
Yes, because we have given our own my lord experience. And my lord, we have evaluated both the my lord parties pursuant to that condition. It's not that my lord, in case of petitioner, we have my lord resorted to that my lord condition, and in case of the respondent,
Then when you come to page 71,
Right.
page 71 says minimum average annual turnover of the bidder for 3 years.
Right.
Then years of past experience required for safe tribunal service. 3 years. So this is also not
Yeah,
ready.
because my lord, because that's why my lord, Lord Shiva rightly pointed out. This my lord, our terms and condition has been set out. We have only followed that.
So this minimum average annual turnover that is mentioned in page 71, this is also not part of the tender. It is also not part of, no.
Yes,
So
that's
that
what,
is also not.
may I clarify that part? My lord, so far as the scope of work is concerned, I was verified. Turnover part is not a condition there. So there is no conflict. Otherwise, I can, my lord, I've already gone through it, my lord, from condition number 1 to condition number 30. There is no, my lord, turnover.
That's not, that, this, first of all, they think it's proof of work. Just clarify that aspect. Proof of work. They think that proof of work only starts from page 79. So page 79 and proof of work does not start. It, it's a fact. Just to make it clear, may I take the point? Where they are saying, about what comes, page 180, page 78. Yes. So it is governed by letters of yes, comma, conditions stipulated in the bid and service level agreement fixed service as by the party. Yes. However, in case if any condition specified in the general contract is contradicted by the condition stipulated in the agreement, then it will override the condition. There are three separate options. Number one is general contract, comma, conditions stipulated in the bid and service level agreement. However, in case if any condition specified in the general terms and conditions is contradicted by the condition stipulated in the service level agreement, then it will override the condition. Now, let us understand what. If we click on this, it is not in this, so everyone is clicking. Then if we click on general terms, what will come is that page up. They are trying to project the picture as if prior page 78 are all general terms, and after this talks about some over. Those are quickly. It has been, it will be clear from the introduction and click on. What is general terms and conditions can be answered. These documents are electronic record published by JAM under the provisions of the Economic Act and the rules made thereon as applicable and shall act as valid agreement between seller, service provider, and buyer. Further, the use of GM for sale, purchase, or loan services and the resulting contract shall be governed by the following following general terms and conditions. They have been trying to give a picture that anything prior to page 79 CNIT is general terms and conditions. It is not. It is only those terms and conditions that find that document at page 130 onward are the general terms and conditions. This is where they have that word following is very convenient not to be overlooked. Now, if we, in this context, if we come back to page 78, that is famous. So there are some terms and conditions. That is why I say the judgment of the Supreme Court in Navodaya Vidyalaya Committee case. He is right when he says that these up to page 78, like for example, there is a from page 71, minimum average turnover of those bidders. So that 800 lakhs is something that the buyer put in. This condition will be there. Minimum turnover has to be there. What would be the extent of the turnover? Earlier it was of the, now they have changed it to 800. Similar is the position. When you are contract, this will be there.
only that 40%, 50% and 80% can attain. And that is how it was changed. It was 35%. So this will be the percentage has given by design. That is the number. And they have consciously given it 40%. So once having declared that, how can they ignore it? Now, again, this taking physical business, again, there are paid money. There is one important word which is never emphasized. Your logic will come back to page one. And your logical reach the condition. What will take precedence and bottom? All supply of medical oxygen to this contract here have been governed by the following set of general terms and conditions for goods and services. That is at page 130. Number two, service specific terms and conditions SPC contained in this document. This portion is not adopted. Whatever is there in this document, that is page 18 onward. With reverse of specific additional terms and conditions as specified by the buyer. Now that 40%, 50%, and 80% is the term specified by the buyer himself. No one asked them to put that 40%, 50%. They have this. Now, what happens if there is a contract? The above terms and conditions are in first order of precedence. That is 86%. Service specific, which next is very important. Whenever there are any conflicting provisions, there has to be a conflict between two. Now, if you read at page and if you read for 4 at page 73, is there any conflict that is available? Just both simple questions myself. Where, as you think, hypothetically, for its designation of senior advocate, application there is a eligibility criteria that he has to be an advocate because an MBBS degree holder cannot become a senior advocate. An engineer with a BE degree cannot become a senior advocate. So that becomes then there is a restriction that he will have 10 years of practice. That experience will be quantified. Where is the quantification of period? There is no quantification. That is why during my officials that are making a case, to accept the proposition as being founded by what your office have to hold is that anyone who has supplied even 1 kilogram of got 300 better. Can that be found?
Anything else? Anything else?
Now, my lord, one judgment is because they have been referring repeatedly to that the employer has complete authority.
AFCON.
In fact, 2020 volume 17 SCC 5
2020 volume 7 SCC
volume 17 is
volume 17 SCC
577.
577.
I am relying on para 16. But before that, you're not to come to para 15. AFCON, exact the paragraph that has been referred to by my director just now is referred at para 15. It is quoted. As my lord got.
Yes.
My learned friend read out this paragraph 15 of AFCON. And now you'll also turn to para 15.
Yes.
It is clear, even on a reading of this judgment, that the word used in the tender document cannot be ignored or treated as redundant or they must be given meaning as their necessary. Given the fact that the case and complied with not complied, the appellant would have no power to condone the act of compliance. Any such condonation has been done would amount to pervert in the understanding or of the tender condition, which must be interfered with by us.
That was in case where the essential conditions of a contract. So in that.
Yeah, that's essential because otherwise, how does the judge what is the extent of? So therefore, they can. So therefore, it would incorrect to say that one has no cost, because minus that, there is no way of determining the extent of this activity. There is no other provision in the entire NIC that gives them the opportunity to determine what is the extent of. That's my opinion. And you will also have noticed that they have not tried neither the responsible, and in fact, my learned friend, they have virtually opted hands off of the activate the responsible where it is unredacted. And he puts in a oath saying that this is how he has submitted. Now, if it is the redacted portion that has been given, my learned friend Mr. Kane Choudhury's argument was even a subjective satisfaction has to be determined. If it is redacted, the objectivity is the mechanism not there. What is the extent here for time? So how does that decide? Where was the objectivity? So therefore, look at all possible angles. There has been daring, perversity, daring on that is and here you are not.
One more question, still conflict, still conflict, thank you. There, my lord, just T-36 means my lord, I say that. Not a-
That are not.
Who will lay down which is the, my lord, mandatory clause or any other? That's it.
I'm not even.
Three paragraph.
Para
47,
47, 48. Yes. We'll step over just one thing. According to you, but that clause 3 of page 80, but that experience part, whether that comes under GTC, STC or ATC, according to you.
well, we have stated it's the default clause. We have stated in the affidavit, I cannot go beyond that.
No. See, page 80, I'm not talking about page 73, I'm talking about page 80.
Which is under the scope of work. Under, my lord, the
So it's so if that is the case, it does not come under the preamble A 1, 2, 3.
but it comes under three, that's my.
That's what I'm asking you. That's what I'm asking you.
Yes, three, Roman three,
Because 3 is 80.
Yes.
So it comes under 80.
because we have incorporated.
So, no, I want to be very clear.
Yes, yes, my lord.
Please read page 182.
Yes, my lord,
You get it. So
Yes, ma'am.
according to you, clause 3
Yes.
of page 80 comes within the word etc as provided in preamble 1A Roman 3.
yes, 1A Roman, page 1A.
That is what I want to
Because it says, my lord, by the buyer. So we have there and 52.
just a minute. The clause 3 of page 80 comes within 86. That is preamble 1A. So,
Got it.
and there clause 473 comes within GTC.
So we are saying, my lord, in the affidavit that there is a default. clause. There is no.
That is a default clause.
Yes,
Okay.
I cannot define.
So, clause 4 of page 73 is a default clause. What do you mean by default clause?
Default, my lord, not to be considered, my lord, in this case.
Not to be considered.
Default is a.
Not to be, default
Not
is
relevant
actually
for- It was there in the, my lord, exam portal itself.
not to be considered.
Not to be.
So not to be
Not to be. Default.
Default is not
Actually,
to be considered.
there is a
Default is
term
when
where
the other conditions cannot apply. Then this should apply.
So there's a term they we use, my lord, might be not appropriate, but that's what.
But then I have got to go by the term you use, not as the term that you want it to be understood as.
But my lord, we have, my lord, under this step, as per our, my lord, there is the, my lord, general terms and conditions, that, my lord, service level agreement, then, my lord, scope of work, which is under Roman 3.
The words you use in your affidavit has to be interpreted as per the words used. When you say someone is running, I cannot say he's walking very fast.
I understand.
Okay, it has to
That's
be
why
he's
I'm
running.
not debating also, whatever is there, is there.
Okay, right. Heard Mr. I Chowdhury.
And last melody in the affidavit, that knowledge and record, I melody inadvertently partly part has made a left out. If otherwise melody I have mentioned C1 to C Roman 3 Roman 1 to 3 Roman 3 para is knowledge and it's partly recorded. That's why I mentioned in both parts. My fault, man, I other partly we have derived that kind of knowledge from the record. That kind of this particular document are the documents uploaded by record number 3. Is the knowledge derived from the record. That's why it's partly. I hope my other section was posted.
Very interesting. Why did the respondent number 3 give you a redacted document?
That I.
Huh?
My lord, one thing, my lord, one thing, he can always.
Redacted. The very basis is accepted.
He gave redacted, but in his affidavit, he's given without the redacted. So I do not know which one he's given.
That, my lord, the petitioner can always point out before the authority by a representation that this has happened. So,
No, he has pointed out now. It's there. They have given, and it's all reported. It's all reported. So, Mr. Ken Chaudhary was saying that subjective satisfaction has to be made on the basis of objective material.
And my argument is, it's not the same argument. That objective material, once it was redacted, that objective material is not the
Well, the in-depth study done by the council shows that a lot of instructions are required now. Okay, right, we've heard Mr. I Chaudhary for the petitioner, assisted by Mr. K.P. Pathak. Also heard Mr. V. Hoy, for the council for the response number 1 and also heard Mr. K. Chaudhary, Leather Senior Counsel for the respondent number 3, assisted by Mr. Vijay. I said, there is one thing I wanted to ask you. Your prayer is a repeating.
write down technical.
Wait, let it do.
That is the illegal. That affidavit, that is cut down. Consequences stop.
Right. The petition is retrieved with the is retrieved with the decision of the state responsible. Is system. Is coming to a finding that the technical bit of the respondent number 6 for supply of liquid medical oxygen pursuant to the NIT dated 7/6/2024 was responsible. The petitioner challenge to the state respondent finding the technical bid of the respondent number 6 as responsive is basically on the ground that the respondent number 3 did not have the past experience for supplying liquid medical oxygen in terms of clause 4 of the NIT. This page 73 would be clause 4 of what? Clause 4 of then what about page 80? What is
That is the clause 3 of the terms and conditions.
clause 4 of the NIT? Clause 4 of the NIT. Read with clause 3 of the terms and conditions. Next paragraph. Clause 3 of the terms and no, clause 3 of the terms and conditions. The just say, clause 4 of the NIT and clause 3 of the terms and conditions states as follows. Clause 4 will be at page 70. And or it will be at page 80. The case of the petition is that an NIT dated 8/5/2020 has been issued by the state respondent for supply of liquid medical oxygen, LMO in short. And the technical bid of the respondent number 6 was disqualified at the technical bid evaluation stage of and the no. This, the petitioner was given contract, was awarded the contract, correct? The first NIT,
The first NIT, it was cancelled.
you're not, okay.
It was
What
cancelled.
do I say? The the contract should have been awarded to the petitioner. So, however, the state response cancelled the tender proceeding, for which the petitioner made a challenge to the state by WPC 3428 of 2023.
That tender, that was awarded to us. At the second.
That is what I'm saying. Now, let's start at the beginning where first off, the petitioner was awarded the contract while the technical bid of the respondent number 6 to disqualify as a technical bid evaluation. However, the contract was cancelled. Correct?
He challenged.
He challenged in a writ petition.
He challenged it in a repetition. That repetition is pending, no. Now it is in progress, but that repetition is pending. He challenged. it.
Okay. So this 342 of 2020 is filed by him. Uttam. The respondent number 3 made a challenge to the award of the contract in favor of the petition by WPC 3428 of 2020. Then what happened? The order was given. And during the proceedings, it was cancelled. And during the proceedings of WPC,
That petition, your lordship, that contract period is over, and that petition is still pending. It is perhaps in structures.
okay, that contract is finished.
That contract, we have completed that.
The repetition, he has completed the tenure of contract. Thereafter, test paper waiting.
Okay, there were 3 tenders.
So how does that matter? Okay,
It doesn't matter, your lordship. That
What is
period is over.
cut that entire. Next, correct. The case of the petitioner is that a notice inviting the tender dated 12/6/2020 was issued by the state respondent for supply of LMO. The petitioner and the respondent number 3 participated in the selection process. And at the technical bid evaluation stage of both the technical bid, so the technical bid of both the petitioner and the respondent number were declared to be responsive. The petitioner was, so the respondent number 3 was thereafter awarded the contract. Yes, sir. The counsel for the petitioner submit that the respondent number 3 could not have the submit that the technical bid of the petition of the respondent number 3 should have been disqualified at the technical bid evaluation stage. As the respondent number 3 did not have the eligibility criteria pertaining to experience in terms of clause 3 of the terms and conditions and clause 4 of the tender notice. And a clause 4 of the NIP, then with clause 3 of the terms and conditions. He submit that in terms of clause 3 of the terms and conditions, a bidder has to have an experience of supplying LMO to one government/private hospital having a minimum of 300 beds. So further supporting copies of supply order from a contract slash contract slash approved price slip with satisfactory completion slash performance certificates and other documents have to be put up. The petitioner, the bidder has to also have past experience of having completed at least three similar services, not less than the amount equal to 40% of the estimated cost, or two similar completed services not less than the amount equal to 50% of the estimated amount, or one similar completed service consisting of not less than an amount equal to 80% of the estimated cost. Next up, the petitioner's counsel submits that a perusal of the requirement of the state respondent is provided in the tender document under the heading, under the tender, under the NIT, under the heading, technical specifications for supply of elements. Wherein the required quantities of elements are to be supplied to the following locations, some of which are as follows. Page 79 in red, 79 and 80. This zero. Next up. The petitioner found that the addition of the required quantities of LMO as provided with the NIT shows that 6995 metric tons of LMO is required to be supplied to the state respondent pursuant to the NIT dated 12/6/2022. He further submits that in terms of clause 4 of the NIT, the amount of the cost of three similar completed services not less than the amount equal to 40% of the estimated cost would be 13.91 crores. Now, would be 5.56 crores. In respect of two similar completed services costing not less than the amount equal to 50% of the estimated cost, the amount would be 6.96 crores. And for one similar completed service costing not less than the amount equal to 80% of the estimated cost would be rupees 11.7. I said before that I have said that just after the chart, I have said that 569950. At a cost of rupees 13.91 crores. So it's, the petitioner now accepted that the list of documents enclosed by the respondent number 3, along with his document, as can be seen from the portal. Is it? As can be seen from the portal. Shows that the petitioner did not submit any experience certificate. As such, the, there was no material before the respondent did respond to have qualified the tender, the technical bid, to have declared the technical bid of the respondent number 3 as responsive, when no experience certificate has been submitted by the respondent number 3. So, the petition was that despite the list of documents enclosed by the respondent number 3 is big document, not making a mention that experience certificate has been submitted by the respondent number 3. The respondent number 2 in his affidavit in opposition has para C bracket Roman C big, and he has stated that there is that the respondent number 6 fulfill the eligibility criteria mentioned in the scope of work, and the respondent number 3 has submitted the requisite supporting documents in order to fulfill the criteria prescribed in clause 3 of the terms and conditions. Which was also in as initial C bracket fully. Petition comes to subject at a perusal of NHS, the document at NHS only shows that the various experience certificates submitted by the respondent number 6 are redacted document. It has mentioned the value, comma, value and rate of some of the, not the value, but as much as the rate and the rate and the gross and net amount of the material, the LMO supplied by the point number three cannot be done. Further, some of the documents, some of the experience certificates are undated and not on printed stationery. Accordingly, submit that the experience certificate submitted by the respondent number two appears to be a manipulation of the tender document as the list of documents submitted by the respondent number two does not state that documents regarding the experience of the respondent number two have been submitted along with the tender. The learned treated concept for the petitioner for the subject that there is no conflict between clause 4 of the NIT that with clause 3 of the terms and conditions of the NIT. Both are terms, both terms and conditions. Subject without subject, even if we have to consider the experience certificate submitted by the point number, which is in the affidavit filed by the state responsible and the respondent. The state which does not disclose the fact that the point number six has the eligibility criteria regarding experience as required under clause 4 of the NI. Next up. So, Mr. D. Robert, current process for the state respondent Okay. That the disclaimer in the NIT provides that when there is a conflict it provides that the NIT is governed by the bit, the NIT is covered as bit, it is his bit. Bit means NIT. Huh? The submits that the NIT is governed by the general terms and conditions and the conditions stipulated in the bit and the service level agreement specific to this service, as provided in the market, as provided. However, in case of any condition specified in the general terms and conditions is contradicted by the conditions stipulated in the service level agreement, then it will override the condition in the general terms and conditions. A reading of the disclaimer, a reading of the above extract in the disclaimer of the NIT shows that for supply of liquid medical oxygen, the preamble one, the preamble of the service level agreement provides that when there is a conflict between the general terms and conditions for goods and services bracket GTC specific, the service specific terms and conditions bracket SPC contained in the service level agreement and the PID, that reverse auction specific additional terms and conditions bracket ATC as specified by the buyer, the ATC would supersede the STC, which in turn would supersede the GTC, whenever there are conflicting provisions. The service level agreement, or the preamble, no, the preamble to the service level agreement also provides that the purpose of the service level agreement, just ahead, the purpose of the service level agreement, as stated in the preamble, is to provide is to outline the scope of work from a stakeholder obligation and terms and conditions of all services covered as mutually understood by the stakeholder. That page 180. No? It's a big point subject. That clause 4 of the NIT does not come under the service level agreement. Correct. And that the same is a standard term and condition, which is always there in the tender under the GEM portion. We submit that the, the clause 3 of the terms and conditions comes within the APC. That is clause 1 bracket A bracket 3, comma 3, correct? Of the service level agreement. We also submit that clause 4 of the NIT of the NIT is a default clause which cannot be considered in view of the fact that the experience required of a bidder has already been provided in clause 3 of the terms and conditions. Also submit that the technical parameters and the stipulations required by the buyer with regard to all aspects of the supply to be made can be done only by the buyer, and the incorporation of the eligibility criteria by the state respondent as having already been made only in terms of clause 3 of the terms and conditions of the attempt by the petitioner's counsel to bring into to include clause 4 of the NIT as a experience requirement of a bidder should not be cannot be considered. If this in this regard is relied upon the judgments of the Supreme Court in the case of number 1, 2016 SCC 818, para 15, number 2, 2022 6 SCC 127, 12, 15 and 7. Number 3, 2008 16 SCC 215, 40, and 2016 8 SCC 622, 47, 48. That's all. Next, Mr. K. Chaudhary. He's not that you Mr. K. Chaudhary, the learned senior counsel for the respondent number 3. On the other hand, perfect. The stand of the petitioner that only the general terms and conditions for award of the contract in terms of the NIT will prevail by superseding all other issues is not correct, keeping in view the disclaimer provided in the NIT. Graduate, the service level agreement provided for supply of liquid medical kits in terms of clause 1, which is the preamble to the service level agreement. We submit that the quantification, there is no quantification of experience required in clause 3 of the terms and conditions for supply of. There's no such, it happens that as in terms of clause 3 of the terms and conditions, there is no quantification of past supply experience required. Past supply experience of LMO required. It happens that the requisition should be dismissed in a such as the entire case of the petitioner has been made by relying upon clause 4 of the NIT without making a challenge to clause 3 of the terms and conditions. Happens that as there is a contradiction between clause 4 of the NIT and clause 3 of the terms and conditions, combined as much as clause 3 does not require any quantification of the experience to be provided by a bidder, comma. The disclaimer read with the preamble to the service level agreement would come into play. As the as clause 3 of the NIT is a service specific term and condition, bracket STC. I think his case was that it was STC. So, correct? No, it is a general terms and condition of contract. So, according to him, it was a general term and condition. Because that would be superseded by STC. That's right. According to him, it was a GTC. It was a GTC. And that we, and yes, and then the page 80 was a specific. So that's what I said. In as much as it, as clause 3 of the terms and conditions. No, as clause 4. No. As there is clause 3, clause 4. As clause 4 of the NIT was a general term and condition for goods and services bracket TPC. And as no comma, and while and as clause 3 of the terms and conditions was a service specific term and condition, bracket SPC. The conflict between the two would require the STC prevailing over the DT in terms of the preamble to the service level agreement. It has subject that no quantification of the experience was required of a bidder in view of them. Excellent. The KN Chaudhary further subject that in terms of other factual subject that when the bidder clicks upon invert comma scope of work as provided in the NIT, comma, the technical specifications for supply of LMO and the terms and conditions provided therein are open. That the above clearly proves that the what did it prove? What did it prove? Huh? So when it was 79 and 80 was open, so that what the page 80 is a ST. Yes, what have I said? Click. That this is that the page he submits that the technical specifications for supply of elements and the terms and conditions provided therein come within the provisions of ST of service specific terms and conditions, bracket STC. Correct. Comma which supersede clause 4 of the NIT. It submits that the conflict between clause 3 of the term, clause 4 of the NIT and clause, no, where is quantification of the experience of supply of LMO is required is apparent as clause 3 of the terms and conditions does not require quantification of the experience of supply of LMO. Correct? It further submits that unless there is, it further submits that as the petitioner has not made out a case of publicity or malified in the award of in the award of the in the in declaring the technical bid of the petitioner of the response number 3 as responsive from this particular petition. In this regard, we have relied upon the judgment that how many judgments? The judgment of the Supreme Court in the case of, uh, 2023, FCC online, FC 1051, para 20. Did I put Mr. The petitioner? I did not know. The petitioner, right? In support of his submission, he has relied upon the judgment of the judgment of the Supreme Court in number 1, 1999, 1 FCC 492, para 9, 10, 11. 19, number 2, 1979, 3 FCC 489, para 10. Then, para 10, which starts with the words, it is a well settled rule. Say that. Then, number 3, 2022, 5 SCC 360, para 6. That's all. Have I missed out anything on the fact? Tell me, because I'm not going to listen anymore.
1020, 17,
What?
1020, 17, 65, 76.
2000 or 2020? It is 2020, 17.
That judgment which was which the learned senior council referred to the very end your lordship. 2020, 17 SCC,
2020,
Yes.
2020, 17 SCC,
57.
577, 1560. Acha, just one more thing, The counsel for the, then next to it, I have heard the counsel for the party, then you write one. Page 182. Clause 1, put the bracket A, put the bracket 2, Roman. Page. This is page, not page 182, and it's contained in this document. Yes. Hold. Then you say number 2. Document, you say one more right. Mr. Ken Chowdhury has also submitted a list of documents to this court, which he says, which he states is the document submitted by the respondent number 6, which the tender document to the state respondent pursuant to the NIT. Hearing concluded, judgment. So facts I have not missed out, I think. Please tell me, because I do this only because I don't want to, you also say that, we did not take up this point. Think the other person, that's the other person. Okay, Anupam. Yes. Thank you. Yes.
They play one thing. This better one eye there for stay vacating. Instead of for stay vacating.
Will this put the entire matter?
Yes, yes. The entire matter will be taken. That's my. Yes.
Yes, sir. Mr. Saiwala, you're the petitioner.
No one.
I'm the applicant.
Okay, okay. Give me the. Will you finish? Wait, will you finish?
It will take some time, man.
How much time?
Again, well, the documents are clear. For the, if I have been noted in the your portal.
Your case is that his bid is less by 3 rupees.
Yes.
Your case is that his bid is less by 3 rupees. Correct.
And that's why it has rejected, on the specific.
And his case was that he could not submit one consolidated bid. And he made it into
This case is that, my lord, the petitioner bifurcated the amount, my lord.
who is the petitioner? He's the petitioner.
The MK Chaudhary was saying.
Okay.
The government stand is that, my lord, the petitioner's bill is not eligible because 3 rupees less. And in the pre-bid meeting, my lord, that was clarified, and the petitioner was represented in pre-bid.
So how much time will you take?
I think take us some time. The document, but that, section of it, and for that day, Malone, it has the award in my. I think there's a very serious violation of the RFP request for proposal.
No, I'm not on that. You see, I don't want to, if I'm going to, if I can, if it can be disposed of, it's okay. If it cannot be finished, if your submissions will not finish within this time period, then we have to adjourn.
One document is supplied,
Where is the document?
but seven fellow, they have uploaded with your portal.
So where is the document? Yeah.
Not the fellow, on the last day, Lordship, your Lordship have directed the notification to be given to this honorable court. That notice of intention to award was never notified.
My lord, that is not applicable for the petitioner, my lord. We have queried, my lord. Mail has been received today from the portal, DAM portal. It's a Government of India platform, my lord, for tenders. DEM, Government E-Marketplace.
Yes, how long will you take? No citation.
No, citation.
Are you ready? Are you ready?
I'm ready.
Only one. Fellow, one document is supplied.
So is the document there?
Yes.
Can you show it to your other side also? He has to see it.
The direction of your lordship was to produce the record, so by the.
Yes, I have to.
Yes, whether part of that particular.
So just see, that's what I'm asking you to see also.
Notice of intention was whether it was.
That notice of intention.
That for that, my lord, I have given the reply, the mail. That is not applicable for the petitioner.
That was the direction given by the court to produce the record, so that might not be notice of intention was public.
No, he's saying that the notice of intention is not a requirement
Yes.
in this case.
That-
So they'll have to show this court that it is not a requirement.
But that's given.
But that has been given.
That cannot, that's the,
So anyway,
This is the minutes of the meeting, my lord. Well, after the opening of the bid, my lord, we have sent one clarification, my lord, letter to the petitioner. Why they have put a lower rate, my lord? Then thereafter they replied also, my. And in these minutes of the meeting, my lord, that all those were considered.
no, where is the letter? Where the notification of intention to award the contract?
That is what your lordship wanted to see by.
You're for the petitioner.
I am.
This is the minute.
Yes, minutes of the our meeting. where his reply and our query, everything has been considered.
Reply to what?
Reply, they have replied why they have quoted, my lord, lower than the minimum price.
That is not the amount of question that was asked, but they are trying to kind of perfect it for the bleed issue. Because, my lord, I have satisfied lordship on the previous occasion, my lord, there are three clauses which are required to be followed before you issue the work order. The clauses your lordship will kindly see, my lord, clause 12, 30, and 31. That's it, my lord. Let me satisfy your lordship.
Let us see 30.1, where is that?
Your lordship may kindly come to page 89 first, my.
Of the repetition?
Yes, ma'am. Page 89.
89.
Page 89 of the repetition. Yes. Because, my lord, the other clauses are to be seen in the light of, my lord, this clause, what is the requirement? I satisfy your lordship, my lord, this has been changed by them by way of a minute, my lord, which was not uploaded. And we are present, my lord, my representative was present, and the, my lord, document they have,
I think you all are going to take that.
it will take some time, my lord, the way, my lord, the objection is.
Only one problem, my lord. Problem is with us, because within 30
We can-
hours,
Ah,
we have to complete the project, man.
in 30 August.
30 hours.
Oh, it will be.
Because no,
Oh,
not
yes,
this
yes.
case, my lord, the project. Otherwise, my lord,
There
federal government will not release.
Tomorrow is Friday. Tomorrow, no chance. Next week. Yeah.
As a first item, my lord.
No, we can't. Today also, we are given the 9 and 10 was supposed to be had as the first item today. I did not allow it.
Six numbers of
Item 2 took so much
central
time.
government projects are going on, my lord. Without it,
Huh?
we will fail, my lord.
It was- We can try on Tuesday or Monday we can try. Monday? We can try Monday. I will try Monday. Let me get back. You'll get everything ready Monday, yeah?
My lord, one more prayer. So it may allow one of my officials to
Sure.
that may be referred.
Correct.
Otherwise,
Okay, right. Heard Mr. M.K. Chowdhury for the petitioner. Mr. Yes, I have order for the number 3. Point number 3 and Mr. S. Datta for state one. On the consent of with the consent of the parties, is the matter on Monday. Mr. P. Datta shall also bring a officer to explain and the report.
The interim order, my lord, interim order is still today, my.
Huh?
Interim order
To continue till the next. Otherwise, we won't finish. I'm quite sure.
one observation may be there.
No, it's a
One
motion.
submission may be recorded.
We'll be able to do it. Second half, we'll be able to do it. Even if you know it's a motion day.
Doctor may record one submission, my lord, regarding the interim. As the interim, my lord, was issued on 12, and already agreement was signed on 10, my
which
lord.
was not informed by the, my lord, council, who was present, my lord, who was served to the notice 2 days prior to that, that an agreement has already been signed. That was not, my lord, informed to the
On
court
the
of that.
very first day motion gave, I was not aware, my lord. On the very first day, that
Then your
was
worship will
holiday
pick up the
for my
entire
lord.
matter.
What do you want?
My lord, I'm just submitting, my lord, to record one line. That already, my lord, two teams, my lord, already they have submitted the draft for detail.
We'll take it up on Monday. Everything will finish. We'll finish it up. Don't worry.
All right.
Yes, this is also a long matter.
Yes.
It's a very long matter. Actually, they are fighting over 5 petrol pumps.
Two.
Two.
Out of three pilot, assessment and
Out of three. So two.
But it's not a fight about petrol pump.
Huh?
It's not a fight, it's not a suit for petrol
Anyway,
pump.
it's a share of it. Yeah.
So it is not even that, your lordship.
Then what is it?
It's the impugned order is suspension of supplies to me. That is impugned. There's a suit pending for, so they were trying to, I was here trying to,
This issue will take some time.
yeah, it will take some time.
Like whatever order we have passed into this, that is also to be earlier direction of my lord earlier. That is a order, but it will take some time.
That is what. Now what to do? No. We cannot, the other case also, we can't take because Tuesday we have packed.
In fact, my lord, on the last petition, your lordship takes this matter today, so that my lord, will sign the affidavit. It has been signed. Your lordship, my lord, become good. Otherwise, the matter will be hard and that's much of the significant file.
Ah,
We find,
have you filed the affidavit?
Yes.
Okay.
yes, your lord.
Yes, it was not to be listed for hearing today, only to ensure that they have filed their affidavit. Thursday also. Thursday. Okay, we can try on Thursday, right? On the consent of the parties, is the matter on Thursday.
Like,
Yes. Whether the writ petition has become instructed or not,
My lord, for me, that is the infrastructure.
for the petitioner,
Otherwise, even they have raised all dispute of question of fact in this. We have raised that at the very first day. And
who is the parent?
even, yesterday I met the council, Mr. Arthur appeared one, spoke sir.
Mr. Miss P. Nath, on behalf of J. Roy.
There.
Okay, we'll give them one chance,
Some other department.
right? No one appears for the petitioner. Mr. Arthur appears for the, respondent. For the respondent. The counsel for the petitioner was to please instructions as to whether the writ petition has become infructuous. In view of the fact that the matter pertains to the prayer of the petitioner for extension of the lease for running the guest house in terms of the representation made by him in the year 2019 and 20.
That part government has already taken over, they have built an office.
Probably in 2019-20, now it is present, we ask them for time.
It was in the directorate building.
Ah.
So government has already distributed the rooms to government officers.
We will give them one last chance is given to the petitioners to obtain instructions, in as much as Mr. Ardhar submit that the guest house has been demolished and
Not demolished, but distributed. It's in the top.
in as much as what office complex has been constructed over the guest house.
It's being used. That
Okay.
guest house-
In as much as the guest house is being used as an office,
Converted.
it is being has been converted into an office of the which department? Tourism.
Directorate of, handloom and textile.
And Directorate of Office of the Directorate of Handloom and Textile. List the matter on Monday.
In this case,
Huh?
admission was required. I got the instruction
Yes,
from the Udalguri division.
yes, any dues?
Yes, sir. 8 lakh, exact amount, my lord.
Oh,
So, for 2 divisions, my lord, 2 liability credit.
how much? 8 lakh?
8,00331.
No, then it is different.
The earlier one is from the Mohammed division.
Mongoldo is 958.
Yes, for Udalguri is
It's 8 lakh 300.
for Udalguri.
Yes, Udalguri. So his claim is for 18 lakhs. It comes less than 18 lakhs.
But it's the admissible amount.
This is the admissible amount.
It's the director to release the admissible amount.
Right, Mr.
M. Das.
M. Das, learned counsel for the petitioner, as well as Mr. P. Gogoi, learned standing counsel, PWD. The petitioner's counsel submits. We'll pass it in one order, common order.
Yes, yes.
The petitioner's counsel submits that the total contractual dues payable to the petitioner by the PWD for the contract works done by him amounts to rupees 18,14,331. Full stop. No, 84,331 in WPC 441/2020 and 217/217/28.
But the 1217 is already disposed of by a law.
Oh, already disposed of.
Yes, yes. that is
Okay.
so.
Then why is it still here?
These fit between is effect. They are connected.
Okay. That's been closed.
Also, common order was passed.
Okay. Okay, on the last day. Okay. Then you write, the petitioner's counsel submit that the PWD have to have contractual bills amounting to, no, submits that the petitioner's contractual bills amounting to rupees 18,14,61 have not been paid. So stop. Next paragraph. Mr. B. Gogoi, the learned counsel for the PWD submit that as per instructions received by him, the admitted liability payable to the petitioner by the Public Works Department, Mongoldoy
And Dolga.
Road Division. Road Division,
So it is
Mr.
on
Petitioner.
Dolga and Dolgaon Territorial Road Division. Territorial Road Division.
Mongoldoy,
Mongoldoy and Dolgaon Territorial Road Division.
Mongoldoy and Dalgaon Territorial Road Division. And is rupees 9,58,405.
Yes.
So, sir, in respect of
Udalgu.
the admitted amount payable to the petitioner on the part of the Udalpuri bracket R&B division, PWD, is rupees 8,00,331 in terms of letter number URBD CC 2019 2087 dated 25/7/2024 issued by the executive engineer PWD Udalpuri R&B division South. Next up. In view of the PWD of the Mongoldoy and Dalgaon Territorial Road Division and Udalpuri R&B Division PWD having admitted that they owe the petitioner the admitted amount of rupees 9,58,405 plus 8,00,331 equaling totaling totaling 17,58,736. Correct? The respondents are directed to pay the admitted amount to the petitioner within a period of 4 months. 4 months from the date of receipt of a certified copy of the report.
There's a liberty in respect of annexure B. There's an amount of 55,595 in respect of FDR to MD Road, PS under Mongolder Road Division for 2004, 2005. Only that remain, that amount is.
What?
Annexure B.
There is no first of, liberty is given to the petitioner to approach the appropriate forum for, with regard to non-payment of his other dues. That's for law. Public satisfaction accordingly disposed. That's all. Should I say civil court? No, no. Should I say civil court or appropriate?
Not
forum?
the appropriate forum. We may even approach the authorities because the amount is very small,
Okay.
55,000.
Okay.
Okay, sir.
Yes, what to do?
Okay, what does the file?
Acha, I'll tell you, right? The letter dated so is made a part of the recorded mark of the next year act. I'll have to sign.
Next to 17 is the liability statement for it. It's an admitted amount.
No, but then the problem is out here. Clarification is still awaited. But today's letter.
Lordship, on last occasion also they took time for filing affidavit.
They did not met the one of the deputy commissioner as a part.
Lordship, revenue, this is FDR and.
If the FDRF this goes to come out for the deputy commissioner.
Revenue is.
We'll fix a date. Miss J. Hunting, counsel for the revenue department. Has submitted a letter dated 1/8/2024 issued by the Joint Secretary to the Government of Assam Revenue and DM Department. Requesting some more time to submit instruction. The prayer of the respondent is allowed. List the matter on liberty. 16. Get come on, to enable Mr. J. Handy to obtain instructions.
Yeah. More time to get the instruction.
So I'm a small enterprise. I think bills are getting
Small enterprise,
2021.
Having into 1.6 would.
Since December, my lord, they have been in time.
But you see, money, unless you see, it has to carry interest, it has to circulate. Otherwise, they take loans also. This Yes.
What to in this time, melody?
In fact, under the MSC,
Huh?
my lord, I am entitled for interest.
Correct.
Under the MSC, we have granted
Under that is the interest is very high.
and very high,
Very
3
high.
times the bank.
People last month.
Mr. L. Bora is given 2 weeks time as a last time to obtain instruction with regard to the payment of dues made by them. With regard to the claim for payment of dues made by the petitioner. This is the matter of.
All right.
Can you produce the last quarter?
I know, madam. Look, yalla only taking time, madam. Huh? Should we?
Yes, part of it, but it's. To complete the list or.
They'll never complete the list, madam. If they complete the list, they'll have to start paying. They don't want to complete the list. You shall give next week. What? You shall give the money or what?
How, when they will.
That is not what we wanted to know. We wanted to know when the first installment of the SOPT fund, whether it has been received or not. Then we will call them, then we'll send the warrant of arrest. Huh? Miss RP Bora, pray for time to one last time to obtain instructions as to whether the first installment of the SOPT fund for the year 2024-25 has been received by the BTC. And as to why the petitioner's case has not been disposed of till. This is the matter. Oh. Next Friday?
Right.
Or after that, after that. You get them, you get it, madam. You have to get, you talk to them, instead of letter will not help. Okay.
The contents are not clear. Can you see the last order? The learned lot, but the Lavazima will not, the order says that the service is complete. They have not appeared thereafter. Regarding non-payment of contractors bill matter, our case is that the chronological order has been broken. And a person who will not submit the bill later on, his bill has been, might have been left out.
Who is the learned senior thing?
Mr. Dina,
Dina.
his name is reflected into the cause.
Is
Not the cause list.
Then what to do? Then then what to do? Either we issue bailable warrant of arrest or what?
But that's the only, that's the option, madam.
That's the only option.
Or Lordship asked for the Dr. Fix another day, madam, or ask for the sending council PWD, madam. This is a PW, this is a Public Works Department, madam. If the sending council will not price will not what happened. I think will not take up the matter with the officer concern. Oh, that's still time for if I can find someone to PWD.
You can find, you can tell a junior to call some government. Otherwise, we'll issue warrant of arrest, bailable warrant of arrest. None of them. This cannot be.
I'll try to find him.
Yeah.
That's
Right. Heard, Mr.
M.
M. Data Learned Counsel for the petitioner to submit that in terms of the order dated 19/9/22 passed in WPC 4700/2020. The respondent were to consider the case of the petitioner for clearing his contractual bill in terms of the judgment, in terms of the full bench judgment of the court in the case of Tamsir Ali, state of Assam, reported in 2003 for GLP 1.
2008 14.
Huh?
8/14. 2008.
2008 for GLP 1. As per the order dated 23/6/2023, notice was issued to the respondent. Next part. Office note dated 4/12/2020. Office note dated 12/7/2020 shows that notices were issued to the respondents number 1 to 6 via registered post office. Office note dated 4/12/2020 states that as the AD card in respect of the notice sent to the respondent number four, bore the initials of the respondent number three. Notice may be deemed to be served upon the respondent. However, there was no return of AD card or unserved notice in respect of the respondent number one and two. Next up. The office note dated 5/2/2024 states that postal consignment tracking details for the notices issued to the respondent number 1 to 3 were not available on the online portal of the postal department. And as such, the matter was to be laid before the was laid before the Lawazima for order. That's that. But, no, you cut that. This, as per office note dated 5/2/2024. No. It is recorded that as per the process server's report, notices in respect of the respondents number 1 and 3 have been received by the respective employees on behalf of them. As for respondent number 2, notice has been duly received by the respondent himself. In view of the above, the Lawazima board said that service upon the respondents number 1 and 3 has been completed. This up. This court, by this order dated 16/2/2020, recorded the submission made by Mr. T. Nathan, a senior government advocate, appearing on behalf of the PWD, that he would take necessary steps for apprising the respondents number 1 to 3 about the incident proceeding. However, no one appeared on behalf of the respondents number 1 to 3. So are they coming or should I?
Gogo is in the 17th, but it
No, because either that or I have to issue some what over. So stop, right? They're not coming in. So if they don't come, though I don't want to do it, I'll have to do it. Right. The address, the address of the respondent numbers 1 to 3. As given in the contempt petition are as follows. As there is, as the, this is a contempt case. It appears that they have received notice. Chief engineer, super engineer, and what another, three of them. So they have not appeared. So on the last day, Mr. Dinath had submitted before the court that he would apprise the respondents 1 to 3 about the, but they have not come today. So there's only one option left for them. the address of the respondent, Kalpana, the address of the respondent, you cut that, that is not required. What to do?
Either the discussion comes, I think I cannot take.
Okay, then you're right.
What I can do is, my lord, I also can.
Otherwise, I'm going to issue warrant of arrest, bailable warrant of arrest. To be executed through the CJM. No, but then who is going to take, I'm not, you see, you're for the PWD.
Yes, sir.
Then you talk to them, tell them that otherwise I will have got to what to do otherwise if they're not coming despite the receipt of notice.
Yes, sir.
Because if in any way, my lord, see, once charge is framed against them under contempt, then they have to appeal before the court anyway. What to do?
I know he has retired sometime back.
Maybe.
One
One and two, you talk to them.
One and two.
Yeah. Right, Mr. Dinath. No, our the government, senior government commits that he will inform the respondents number one and about the proceeding, about the present proceeding. He further submits that as per his knowledge, as per his information, the respondent number three has retired. This is the matter when.
I think it's after one.
See what it is.
The cause list may reflect his name, so that he can also.
No.
Otherwise,
no.
again, miss the item.
Contempt is, my lord, so.
No contempt is not.
Until I can follow some other.
It isn't just
I
helping out.
understand that.
It just because otherwise we have got to do a pass an order which is not very. I understand.
Then, option fix is date, 12th of.
Welcome. Yes, what is this matter?
Yes, perfect. Offense, it would be funded, was floated by the Assam and it's for but negative that part and was substituted by the PG. After that, by the what deposit the balance amount method, it is a particular part of there. There, it got the remaining amount and subsequently that often saver now what I'm saying that one particular that number was not met. There. That is that was the issue. That method is we can have to put it about this.
Yes, where is the mortgage deed?
Statement was then is that total land is 3 bigha. And the involvement is the 2 that.
No.
Yes, sir, coming method.
Let us see the auction notice.
Option notice will let you find page number 13 of the 8
38.
13. One.
Clear number one.
13 number one. Address of the MS Supinder Rai Parwa.
There are two arrow in the notice method. And in the name, in the middle name is there arrow. And second is the land is totally 3 bighas. That is correct. But there will be 2 dark.
No, MS Supinder Rai, number one only, no?
Number 1.
Number one.
So land is 3 bigha, 0K, 0L, 1689, pata number 184.
Yeah, it should have been tag number 1689 and tag number 191918. And patta number
1689,
and 1918.
1918. It should have been two. It should have been two dark numbers.
2 tag number and the patta number is 184. Total area is 3 big. So one is that particular notice, one tag is missing. So it is provided a total.
So 184 pata number is correct.
Correct. That is correct.
Pata
Tag
number is correct.
Patta number is correct.
And one tag number is also correct. There.
One tag is
Another tag number is there. That is
Acha, which one is missing?
1918. And the name of the person, you can write, it should be Bhupen Ray Bolton. The name is also wrong.
But it's R-A-Y-R-O-Y. In Assamese, my lord.
And I have found thinking that there is a document that been provided to me, madam. I think it's very good. So these two tags will cover the entire three data. And this will not cover the entire three data. Ultimately, this erroneous notice has been, that's why we have recalling it and cancelling it and saying that deposit 10% of the amount. We have returned it, but it's not.
You're getting a higher amount of.
No, I'm not. They're not.
My lord,
Not selling
yes,
it now.
now, my lord, you got the point. They are now, they are some, taking some other path. Because my lord, my knowledge part, I cannot say on report, my lord. The petitioner has informed me that the AFC, my lord, has already been in contact with the, my lord, with the right.
Bhupendra Rai.
Yes, that is the partner, my lord. They are now negotiating with him. I don't know whether, yes, I cannot take any report, but that is why I can.
No, but where is the area is not mentioned there.
The area is there, my lord.
Area is
Now-
there.
Now, what
Typical.
happened is they are taking a very city care, my lord. They are taking it float land. That is totally discredited. They are thinking one level is not there. That's why they are cancelling.
But
Pata
Pata
is there. Pata
Pata is there.
also same.
So that number is of no use.
Only,
No, no.
yes, ma'am.
Well, lot will see the map. But I have flagged it, madam. There is a map. That particular document I have been just now.
And even, my lord,
Yeah, just now. There are three flags. One of the flag is the diagram of that particular sketch. There are two plot of land. If one is missing, you cannot complete. You separate that no one. One is missing.
He's okay with it.
yeah,
This sale notice cannot proceed, my lord.
why
Only
cannot,
a
my
sole-
lord? Three
Huh?
figures
That's
land,
why we are-
I want that.
Huh?
That's why we are calling it.
He wants only one part. He doesn't want the other.
Yes, I am ready.
He wants only one part. That I have to take some instruction. He wants only one part.
But I just need
Are you
that three biggest land, my lord.
Huh?
I just need that three biggest
Then
land.
it will not come to 3 because
Why not, my lord? They are saying that,
No, but
now, my lord, they,
why do you want to
notice that
why? Because he wanted.
person gives a notice.
So he does. No one is causing any problem. He's happy. You have made a mistake. You give him that other paragraph.
original also, they can visually, they can correct it visually also, my lord.
Why do you want to do that?
The notice which has been public notice, the further mention when a notice, it should be correct. We will be now selling in a different plot to single plot of land of certain mortgage to us, to the financial corporation by Bhupendra Rai, Burua. We will be selling only one plot of it. One plot of land will remain, and he has mortgaged that particular plot of land. Two plot of land became 3 bigger. It will not cover.
He has mortgaged both.
Hello?
He has mortgaged both the land.
Both. And now they are in a erroneous notice, they have sold one part. They have given notice for
You
one.
want to sell both.
Yes, both. Then only it will go over 3 bigas. Then it will then now that 3 bigas will be less. An erroneous notice, how can proceed? That's why we have recalled it. And we
My
have
lord,
even
that
deposited
can
the 7
have
lakh
been
you are returning.
already rectified, my lord, by mutually sitting also, my lord. They can
They can
have a
literally
seat
sitting
with
that
my
I have
client,
no
my lord,
customer. They
saying
can
that
come to office.
actually this is a plot of land and this is a tag number, this tag number is, that is not an issue, my lord. My lord, they are having a particular plot of land, that's three biggest land, that is the issue, my lord. That land may different tag, but the land is the patta is same, my
That land might have several darks.
lord. That might have.
Huh?
That does not matter, but
That is a
that-
particular
that
patta
plot
number.
of land, my lord.
The patta is correct.
Patta is correct. It's only mere omission of a tag number method. That does not.
He admits that's the omission.
But if they say 1918 was missing, that is why I'm saying if 1918 missing does not change the whole plot of land, that's significant. That's okay. And they can have rectified also, well. There were ample time, well.
So in the land in say, so that patta number is on two land, on two dark numbers.
There will be multiple tags. Because notice that diagram, there are many tags are in the tag. Correct. And I have highlighted that two plot of land. There will be many tax.
Method. Here method. To occupy Kendra the SMS linkage method. Method there is a base map method calculated by the bundle, flap bundle, the concept bundle to which looking at. Here method that plot of land that is sketch map. Here.
No, even question.
Right now for every. Item exact.
No different. Two different. Your drawing and this drawing is different. That is different. Which one is the one? This one?
This bigger.
Huh? This big one?
That that is that is 1 6 nine is about a time. So 1 6
No, 1689.
1 6
We listed on Wednesday. Wednesday. Let this matter on Wednesday.
getting the
Tuesday, Thursday, we've got 2 minutes. Hearing matters, we've got.
yes.
So the patta number is same, the tag numbers are two.
No, what I'm to say, 46 is a patta. And in between there will be many multiple tags. And there are many lenses. Yes, I got this two tags. Out of this, all advertising is that giving the notice, one tag we have given, and the area is this notice is there on here.
But then if no one is complaining, why?
Yes.
If record will file and will issue a new one that we have recalled it, my lord, because erroneous tag.
No, tell me what is wrong. If you, what will happen to you?
Then we have to go back to the office and find out that particular tag, what is the land measure in that particular tag. That will only be, we'll get a this amount of money.